Lordship, I beg to mention item number 25. Yeah, on behalf of respondent number 5 and 6, Lordship. As Bothakur, Lordship, I am praying for some time.
5 and 6.
For respondent number 5 and 6.
Okay.
Matter may be come up on Lordship 20th.
You file affidavit or
not, Lordship, we are
for filing affidavit? Who is for the petitioner?
I have taken consent.
Okay. Mr.
Islam.
Islam counsel for the petitioner is present. Mr. S.S. Roy.
On behalf of S. Bothakur.
Counsel on behalf of Mr. S. Bothakur and counsel for the respondent number 5 and 6 has sought for and is granted. How much time you need?
Lordship, 2 weeks, Lordship, immediately after 20 or 21.
3 weeks time to file counter affidavit on behalf of the said respondents. Release the case on so and so.
Lordship.
August.
May I please allow?
August.
May I please allow? I'm seeking listing on matter, Your Lordship. In here, the petitioner, he is an elected Gau Panchayat member, Your Lordship. Subsequently, he has been elected as president of a Panchayat. In the meantime, Your Lordship, he has been disqualified and removed from the post of the member, Your Lordship. On the ground of section 100 to 111 subsection 2B, Your Lordship. So this matter may kindly be taken on today, Your Lordship. If it is not possible, then on tomorrow, Your Lordship.
Try.
Tomorrow, Your Lordship.
Today. Try.
May I be I beg to mention also item number 24, Lordship. I have taken consent, Lordship. I am also respondent number 5, Lordship.
Okay. Who is for petitioner? You have informed.
Yes. So,
Mr. A. Dekal and counsel for the respondent number 5. You need time for filing affidavit.
yes, Lordship.
Okay. How much time?
After 2 weeks, vacation.
Okay. 3 weeks. Has paid for and is granted. So it is submitted that consent has been taken from the learned counsel for the petitioner and other respondents to make the prayer. Release the case accordingly on Friends.
Obliged, Lordship.
10/08, 10th August.
We seek your lordship's indulgence to move an urgent application because police is calling me to the police station but not giving any case number, not giving any details. They're simply threatening me that they will arrest me. So we have moved other civil rules for direction to the police to disclose the case numbers and all. Because my personal liberty is at stake. I am a director of a company. So your lordship will kindly permit us to move them
Today?
today. A second up at 2.
Okay. After all motions.
Yes. Deeply honest.
May I please, Your Lordship. Item number 19 of today main list. I may be allowed to withdraw. Because
Okay.
it is case of Thorn and Father. They say I may be allowed to withdraw without any liberty.
Okay. Mr. L.K. Bora, learned counsel for the petitioner, has submitted that he has instruction from the petitioner to not to praise this petition. First of Ms. M. Borman, learned junior government advocate, Assam for the state respondent is present. In view of the above submission made by Mr. Bora, learned counsel for the petitioner, the petition is dismissed as not pressed.
Most please. Thank you.
I'm praying for listing of an unlisted motion, my lord. The extreme urgency is that, my lord, at around 6 p.m. yesterday in the evening, my lord, the circle officer issued a notice for eviction to the petitioner, my lord. In spite of being told that there's an injunction order in the favor of the petitioner, my lord, the notice for eviction is for today, my lord. So, my lord, this has to be heard, my lord, by today itself.
Okay.
All right.
Lordship, I may be allowed to move a listed motion tomorrow. Lordship, the matter relating to land at civil judge has no jurisdiction, and we prayed that our plaint may be returned, but court is not passing any order and take the matter for.
But that is a judicial order.
No, Lordship, no order has been passed till date. But Lordship, the notification has been set aside by your Lordship in commercial court. No fresh notification is issued. We prayed the court that court cannot pass any order. Court said that yeah, I have no.
No, it is a commercial court.
Lordship.
Then it will be division bench only.
No, Lordship, that notification is set aside by your Lordship.
Huh?
By sitting in division bench, your Lordship has set aside.
That is commercial court division bench.
Lordship.
I am not the only one.
No, Lordship, this is against the order of the learned civil judge. Lordship. He is not passing any order. We file an application that our plaint may be returned since the court has no jurisdiction. But court has not passed any order and fixed the matter on 28th of July for maintainability of the suit. And we prayed that since the court has no jurisdiction, court should simply return the plaint for filing before the appropriate court. But
But
in spite of that, court is not.
to my understanding, it will be 227. I don't know.
No, Lordship, we file application under 226 and read with 227.
No, that cannot be. That is not the law. If it is, those are separate. You go through Radheshyam, 3 judges bench.
That's-
You cannot mix up 226 and 227.
But Lordship,
Now, earlier it is read with 226, read with 227. Now it is not the scenario. Now it both have been segregated. You go through Radheshyam, 3 judges bench, accordingly you change 227 or 226. Then you file MPT.
the Lordship may be taken up tomorrow. Lordship.
See first,
No,
file it. File it.
May I please, Your Lordship, Lordship, I also mentioned for listing of a matter for tomorrow, Your Lordship. I have filed it today morning, Your Lordship.
What case?
My GST has been temporarily suspended, Your Lordship, without any notice, Your Lordship. On the basis that I do not have any agreement, Your Lordship, and the agreement.
You have a GST registration.
Lordship,
Proper officer has power to suspend.
Lordship, without any notice, Your Lordship, that was.
The suspension needs notice.
Lordship.
Suspension doesn't need notice.
And my representation is also not been accepted, Your Lordship. It will come up, Your Lordship.
Okay.
May I please, Your Lordship. So I beg to mention item number 42 of supplementary Lordship. This matter may be taken at 2 Lords. The engaged counsel.
No two unless court permits. Next.
May I please, Your Lordship, I beg to mention item number 26.
Yes,
Will file a reply on the consent of the opposite party with.
you want to file reply. You are there.
I am appearing on behalf of my senior and Borough.
Okay, Mr.
A. Rajkot.
A. Rajkot and counsel for the petitioner has prayed for and is granted. How much time?
After petition.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondents. Mr.
Because does
My lord,
B. Das and counsel for the respondent number
123.
123 is present. List the case on so and so.
my lord, there is a interim order.
Interim order. Continue.
1008, 10th August.
Please, Your Lordship, I beg to mention item number 28. We need-
28.
Oh,
Okay, on the prayer of Mr. N.K. Alam, learned counsel for the petitioner.
20.
Matter, list the case after 3 weeks to enable the petitioner to file an affidavit in reply. It is submitted that consent. Consecutive. Yes.
Your Lordship, I'm appearing for respondent number 2 in this case.
Okay, Mr.
S. Sengupta.
Counsel for the respondent number 2 is present.
God bless you.
May I please, Your Lordship. Also, I'm praying for listing of this matter by tomorrow, Lordship. The urgency is a land acquisition matter, Lordship, and I have been issued a notice for handing over the possession of the land. Whereas this issue with regard to the compensation has not been decided for last 2 years. But I have been directed to hand over possession of the land.
Okay.
may I please, Your Lordship, I am praying for listing of the case after reopening, my lord, any date.
Motion.
For admission, my lord, admission.
Give it to the court master.
May I please, Your Lordship. Like to mention for listing a matter for tomorrow. Yesterday we filed, Lordship. Urgency is that for issuing the passport, Lordship. The petitioner husband belongs to the Bangladesh, Lordship, and they were divorced. Now her daughter resided Bangladesh, and now she want to meet. She is severely ill.
Okay.
May I please, Your Lordship, I
I'll
beg to mention item number 30, my lord, 30.
Yes. Mr. P. H.K. Sharma, you are for? Counsel for the petitioner.
First week of August.
Okay. Has sought for listing of the case in the first week of August due to certain difficulty on his part. Mr. B. Goswami, Land Traditional Advocate General, Assam.
Problem. Today he's present, but.
Who is present, has consented to a prayer, list the case on soils.
0608, 6th August.
May it please, Your Lordship, I beg to mention for withdrawal of item 5 and 6 with liberty to file afresh.
Today's.
Yes, Lord.
Your name, please?
Ahmed Shakir.
Mr. A. Shakir, learned counsel for the petitioner, has submitted that he has received instruction from the petitioner to not to praise the petition. Mr. A. Aforesaid, Revenue, M. Borman, Silo number geta. are present. In view of the above submission made by Mr. Shakir, learned counsel for the petition, the petition is dismissed as not placed. Same 6.
Item 5 and 6.
Daily list for motion, item 1.
Please, Your Lordship, I beg to withdraw this matter with liberty because in the meantime, Your Lordship, contender got transferred, new incumbent has joined Your Lordship.
Oh, Mr. R.A. Chaudhary, learned counsel for the petitioner, has submitted that due to subsequent developments resulting in transfer of the respondent from the office of District Commissioner Kachar, the petitioner wants to withdraw the contempt petition in order to file FS with the proper respondent. First of, in view of the above submission made by Mr. Chaudhary, learned counsel for the petitioners, the contempt petition is allowed to be withdrawn, come with the liberty as sought for.
Obliged, Lordship.
Yes.
Lordship, I have received instruction that pursuant to the show cause notice dated 7/6/2007, personal hearing letter dated 29/8/25 was issued to the petitioner, Lordship. The department is just calling the petitioner to file their reply so that the department can complete their adjudication process and drop the proceedings, Lordship. So, Lordship, they may be directed to appear before the authority and file their reply. Accordingly, the department will close the proceedings, Lordship.
You have written instruction.
No, Lordship, I have verbal instructions.
Your Lordship will kindly see the order on 25th of May.
Yes.
So the show cause notice has been challenged on the ground that there cannot be a case of short payment after the issue has been decided. So there is a jurisdictional issue. We cannot participate in something like this.
Okay. Will issue notice?
Lordship.
Heard Mr.
Arnab
A.
Chakraborty.
Chakraborty, learned counsel for the petition, and Mr. K. Jain, learned counsel on behalf of Mr. S. C. Kayal, learned senior counsel and special counsel CZST. Full stop. As let notice be issued. Notice is made returnable on suence. As Mr. Jain has appeared, learned counsel has appeared on behalf of Mr. Jain has appeared and accepted notice on behalf of the respondent number 1. No formal notice is to be issued to the respondent number 1. The learned counsel for the petition shall furnish an extra copy of the petition along with annexer to Mr. Jain by tomorrow.
Lordship.
By tomorrow, post up. The learned counsel for petition shall also furnish a copy of the petition along with annexer to the learned Deputy Solicitor General of India within by tomorrow for service of notice upon the respondent number 2. The respondents may find shall ensure that the counter affidavits are filed before the returnable. The interim or the past earlier shall continue till the next August.
Much obliged.
10th August, 10/08. Item 3.
Please, Your Lordship. Lordship, herein the petitioners are were residents of a particular village, Lordship. Through that village, there was a river.
Yes.
So through that village, Lordship, there was a river which used to flow in small streams, Lordship. So it did not affect the residence of the petitioners. However, Lordship, later on, the two embankments were built on two sides, Lordship. And the river was made to flow in a single stream, Lordship. And that led to submergence of the village of the petitioners, Lordship. So they had to move out of the village, Lordship, but the lands continue to be there to exist in their names, and no compensation has yet been paid to them, Lordship. Although there has been some acknowledgement through.
Well, you should notice at this stage.
Lordship.
Or Mr. S. Day, Learned Counsel for the petitioners. How many?
19.
And Bodole revenue,
For 1 year.
1. And thus,
3, 4, 5.
junior government advocate, some 3, 4, 5. Miss R.M. Deka,
2 and 6.
Learned Standing Council, Water Resources Department, for the respond number 2 and 6. The petitioners from 70, 97 in number have joined together to prefer this writ petition, stating that they have a common cause of action. So in this writ petition, they have sought for compensation. For the parcels of land located at village number 2, Gormora. Under the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013, issue notice returnable on so and so as Ms. Bodole, Ms. Deka, and Mr. Das. Extra copies, who working is.
1208, 12 August. Item 4.
My lord, similar matter came up on 19/6, my lord, regarding that challenge to the notification, my lord. That is also here not as a part in the record, my lord. We are required to file an affidavit, my lord. So immediately after the vacation.
What is the repetition?
My lord,
Number?
that is WPC number 3198 of 2026.
Thank you.
My lord.
The number liquidable. A.R. Bhuyan, Senior Counsel, estate by Mr.
It's S. Abdullah, my lord.
S. Abdullah, Learned Counsel for the petitioner. Single petitioner.
Only one page.
And thus 1, 3, 4, 5.
8, 10, 11.
Okay. 8 Sharma. 8, 10,
Lordship,
11.
11.
Okay.
1 is also Lordship.
1, 3, 4, 5,
8, 10, 11.
8, 10, 11.
Lordship.
A. Aforesaid ji.
For 2.
2. D. Bora, Miss D. Bora, Health and Family Welfare Department. Yes, number 6 and 7. Public Health, R. Google. 9. Anybody left out? Education. Okay, I've read it. Mr. Punya, Learned Senior Counsel. What is the date of the notification?
Lot 27.
Elementary, okay, and Bodole Learned Standing Counsel, Elementary Education Department for the number 12.
27 to 1950.
Okay, same then.
Mal. 13.
37. If I click it, you
Apply.
Item 7.
Yeah, let's just make a, yes,
It is second round of litigation.
second.
Your lordship would be pleased to go to
How many petitioners here?
5 months.
5.
What
is their case?
My lord, their case is this, my lord, they are allottees.
Allottees.
They apply for settlement.
Where are allotments?
Allotment order, my lord, your lordship will get allotment order starts from
মহকুমার ভোগ দখল কৰি উল্লেখিত শর্ত
is from page
তহসিল আবন্টন নিয়ে হয়েছে উত্তরাঞ্চল নিজে ভোগ দখল করে
18 to 33, my lord.
And what is the years? What are the years? 2020. 2020.
And your lordship.
2020.
The revenue receipts from page 40 to 41.
Who has issued all this? Subdivision officer Bilasipa. Yes.
Hello. Now your lordship,
Hmm.
in spite of their application for settlement, we filed the application for settlement, my lord, that is acknowledgement has been received from page 64 to 49, 50,
Allotment to periodic patta.
my lord,
2000. When did you file? 2024.
my lord. Now,
Okay.
now your lordship, in that during tendency of those applications, my lord, were pretend to be evicted. Then I approached before your lordship. And your lordship was pleased to pass an order that they 2 to 26, that is at page 67 to 70. Your lordship would be pleased to see from 60.
What is the service? Allotment certificate to periodic patta.
My lord.
What happened when you that application has not been disposed of?
My lord, that dispose of, then your lordship directed me. If you.
90 days. 90
You
days.
appeal the appeal. I filed the appeal, my lord.
Filed the
at
appeal for
page-
where?
Page 71 to 74. That is the acknowledgement of our appeal, my lord. Page 71 to 74.
Computer right title internet. Not intended to issue notice. But Ms. Bodal has been changed. Revenue.
Now it's DLR receipt.
That day we have disposed of.
Yes, yes, your lordship. First appellate authority is.
Mr. Mondal's
Yes, your
cases.
lordship. Yes,
4
your lordship.
cases.
Yes, your lordship. First appellate
There is
authority.
a notification already. You filed the appeal before
DLRs.
Director of Land Revenue and Survey. He is the appellate authority.
Land records and
But,
survey.
As per this earlier order, my lord, it was the government.
No, that has been, the new notification has come.
Notification dated 9/7/2024.
Yes, my lord.
You go through it, you go through it.
My lord.
We'll take it up after some time. We allow you to file the appeal and we'll give you time also within 1 month to file the appeal before, because we have disposed of.
My lord.
Mr. Mondo, you go through this. We'll take it up after some time.
My lord.
Let him satisfy.
Sir.
Item 8.
Prior to my learned friend starts, lordship, may kindly go through the order dated 5/6/26. We have been directed to provide the copy of the CETA legible copy at page 15. That copy has not yet been provided.
He has replaced in the court, but he has not been given.
No.
My lord,
It is your duty also.
my lord, I instructed our, my lord clerk to provide the copy, my lord.
The clerk is not Answer would be your lordships, my learned friend.
My lord. May I please remark?
He is objecting it to.
My lord,
Have you not understood?
my lord, I will provide it.
Provide him a legible copy.
My lord, during the course of the day.
Then we'll take up.
Lordship.
May it please your lordship.
Yes.
This matter pertains to one notice under section 126 of the BNSS actually. Without following the due
20, which notice? Page?
page number 21, your lordship.
No, one BNSS.
First is on report because there is no due process of law could is not followed. No police report, nothing. First of all, now I am in a very bad pitiable condition right now. I mean,
Mr. Das.
I'll get the instruction.
We keep it in evidence. How old are you?
81 years old.
81 years. Personal appearance. He should. I'll direct him to go to her house. Is this a region order?
I understand.
What if there is an adjudication already?
Yes, my lord.
Is it not?
Yes, yes. Saying with regard to the respondent number, instigation of respondent number 5.
Maybe see there something is there at page. Where is that order? Page 34. Government has passed the order. This complainant has claim only over 2 lessons.
Yes, we are.
He is this.
I will never commit.
This is to. How can that lady of 81 years can
provoke a nuisance in the society?
Bedridden?
Yes. Now in the hospitals are kept under observation. So I'm in bad condition, your lordship.
Hospital presently?
Yes, presently in the hospital. The doctors advise not to be shifted to home also.
Oh.
So right, I think near is very near and is near.
Heard Mr. N. Ajay Learned Counsel for the petitioner. Mr. N. Das.
1 to 4.
1 to 4. Issue notice returnable on so-and-so. As Mr. Das has appeared, accepted. No formal notice, extra notice. The petitioner shall take steps or service of notice upon the respondent number 5 by speed post during 2 working days from today. In this repetition, the petitioner has said, no, the petitioner is a senior citizen and is aged about
81 years.
81 years. Full stop. But in this petition, the petitioner has assailed an order dated 14/5/2026, passed by the respondent number 3, purportedly in exercise of powers under section 126 Bharatiya Nagorik Suraksha Sanhita. Full stop. In the proceedings of Miss Case number 86/2025, in connection with which the order, impugn order has been passed, respondent number 5 is the first party and the petitioner
28(5)
is arrayed as the second party. Close to. When an executive magistrate receives information that any person is likely to commit a breach of the peace or disturb the public tranquility or to do any wrongful act
25 order.
that may probably
205 key order.
occasion
Sorry, 20.
a breach of the peace
21 is 14(5).
or disturb the
24.
public tranquility and is of the opinion that there is sufficient grounds for proceeding, comma,
Order to court. Where is
the
the order?
executive magistrate
No. It's order dated 25.
under section 126 within bracket 1, comma, B and SS may, comma, in the manner provided therein,
Order is here.
comma, require such person to show cause.
Here.
Why he should not be ordered
Notice is.
to execute a bond
Order is 20.
or bail bond
Order
for
is 14.
keeping the
Yeah,
peace
order is 20.
for such period,
It
comma,
has been signed on
not
25.
exceeding 1 year, comma, as the magistrate thinks fit. Post.
Nice. Submit one thing, my lord. In page 21, it says, my lord, to appear before the court on 28/5/2026. That has been already gone, my lord. Today is the month of June.
It should be blanket stay. It is a mandate under section 130 BNSS that when a magistrate acting under section 126, comma, B and SS deems it necessary to require any person to show cause under section 126 BNSS, comma, he shall make an order in writing, comma, setting forth the substance of the information received, comma, the amount of the bond to be executed, comma, the term for which it is to be enforced, and the number of COTs, comma, after considering the sufficiency and fitness of COTs. Post op. The impugn order. Has not set forth the substance of the information received. Post op. It does not meet the requirement of section 126 BNSS read with section 130 BNSS. In such view of the matter, it is ordered that the impugn order shall remain stayed till the disposal until further order.
1208. 12th August.
I have gone through the notification, my lord. If your lordship, please, item number 7 may be taken.
If Monroe. Yes, Das, it's Borman.
Item 7. No to 12,000.
Heard Mr. MSC, Learned Counsel for the Petitioners. Can you give that notification? Who is revenue? Mr. N. Bodole, Miss N. Bodole, Learned Standing Counsel Revenue and Disaster Management Department for the respondent number 1. Miss M. Borman, Learned Junior or Mariposa Assam for the respondent number 2 and 3. Post. Para. The petitions, foreign number, comma, have joined together to prefer the instant repetition under Article 226 of the Constitution to prefer, stating that they have a common cause of action. Post. It is the case of the petitioners that allotment certificate, all.
My lord, all.
This petitioner or their predecessor in interest? Who got
The predecessor in interest and after they
Okay.
are in the position. Not allotment order is in their name. But regarding possession, my lord, first their predecessor in
stated
interest.
that about 50 years earlier, comma, the predecessors in interest of the petitioners have had settled in a parcel of land comma, covered by DAG number 206/178, comma, located at Revenue Village, Santospur, Chapor Revenue Circle, District, Dhubri, Assam. Post. They have the each of the petitioners, the family of each of the petitions are in occupation of an area of land in and around 1 bigha each.
My lord. My lord,
Okay.
somebody 1 katha 5 lesa.
Uh,
Then my lord, 1 bigha
Okay,
1 katha 5
okay.
lesa.
Areas of land measuring 1 katha 5 lesas stroke
1 bigha 1
1
katha 5.
bigha 1 katha 5 lesa stroke 1 bigha. Right?
No, my lord. 1 bigha 5 lesa stroke 1 bigha 1 katha 5 lesa.
From
Mix-
15 only I have said.
Maximum. my
1 katha 5 lesa stroke
My lord.
1 bigha 1 katha 5 lesa
5 lesa.
stroke 1 bigha.
Yes.
That's all.
Oblige, your lordship.
Full stop. They, apart from using the parcel of land for their homestead purposes, they have also, they have been also using.
My lord,
They have
homestead
be-
purposes and remaining land for agriculture.
My
lord.
and homestead purposes and also for plantation. Post op. It is the further case of the petitioners that being landless persons, comma, they applied for allotment of those parcels of land and the respondent authorities. The district admission had issued allotment letters to the present petitioners in the year
2020.
a number of allotment letters which are annexed as Annex number 1, 1A, 1B, 1C, and 1D, respectively, to the writ petition. Post up. In due course, the petitioners submitted applications for the notified public service quote allotment certificate to periodic patta
Lordship,
unquote.
few of the allotment letters are dated 2024, 2004, 2007, Your Lordship. So they are.
I said annexed as annexed. I am not making the
They are
dates.
prior to the existing land policy, Your Lordship. Some allotment letters are prior to the existing land.
We are not
policy.
into merit, only allowing him to file appeal.
Because 1 bigha land is asked, that's why I
No,
pointed
they
out this.
said it is there in their mouth.
Yes, Your Lordship.
It is not the view of the court. They are saying, I am making the statement from their averments.
Yes, Your Lordship.
It is the case of the petitioner.
Yes, Your Lordship.
And the in the designated portal, Seva Setu,
Is that right?
and the applications of the petitioners were duly acknowledged. Most of the application acknowledgements are annexed to the present writ petition as Annexer 4A to Annexer 4C respectively. Post of. Para. As per acknowledgement receipts, the notified public service. Into 6. Conversion of allotment certificate. A correction to periodic patta was to be extended to the petitioners within a period of 90 days from the date of the application. First of. Therefore, the petitioners were waiting for the outcome of their applications. First of. The petitioners have stated that despite submission of their applications on 7/12/2024, – 26/11/2024 and 9/12/2024, and elapse of the statutory period of 90 days for consideration, neither the notified public service had been extended to the petitioners, nor any speaking order had been passed, as mandated by the provisions of the Assam Right to Public Services Act, 2012, as amended. Next 7, this notification. 8. Next 9. As the grievance raised by the petitioners in the present petition is with regard to non-disposal of their applications for the notified public service, conversion of allotment certificate to periodic patta, the petitioners have an alternative, adequate and statutory remedy of preferring an appeal before the first appellate authority, that is the Director of Land Records and Surveys, Assam. So therefore, the writ petition in the given facts and circumstances and in view of availability of the alternative, adequate and statutory remedy, is not entertained, reserving the liberty to the petitioner to avail the remedy of appeal under Section 8 of the Assam Right to Public Services Act. So if the petitioners intend to prefer such appeal, then the same shall be filed before the first appellate authority, that is the Director of Land Records and Surveys, Assam, within a period of 30 days from today. And on filing of such appeal, the first appellate authority shall entertain the appeal and consider the same on its own merits within the time period prescribed in the Assam Right to Public Services Act.
30 days.
30 days I have
30
permitting,
days. Yes.
and he has to entertain and dispose of. It is needless to mention that the appeal is to be disposed of by passing a speaking order within the prescribed period as mandated by the Assam Right to Public Services Act. With the observations made and direction given above, the writ petition is disposed.
But till disposal of our appeal, my lord, we should not be disposed of.
Okay.
Disposes.
As the petitioners have raised an apprehension that the respondent authorities are contemplating their eviction,
Para 11.
The first appellate authority shall also consider such prayer for interim relief if sought for by the petitioners on merits and may pass an interim order as permissible under the law.
But at least your lordship can.
No, I cannot. While not entertaining, I cannot pass interim order. That has been barred by Supreme Court.
On thing. Till
You file.
Let him file.
30 days.
You file tomorrow. I'm still giving you 1 month. And I have directed to entertain the appeal, not to dismiss the appeal.
My prayer was this one.
And he passed a speaking order.
File tomorrow. File tomorrow. Convert the writ petition in the method of appeal. That much is to be done only.
Obliged, Lordship.
Lordship, with regard to item number 8, Lordship. As,
At the later point of time after the motion, don't disturb the continuity.
Item 10.
Yes.
Mr. Lordship, in this case, the petitioner as borrower has taken loan.
Mr.
After that, he has paid regularly.
This is servicey.
No, Lordship. Here, Lordship, the main contention on this, we have
surfacey. He has given one proposal for OTS. The value of the mortgage property is more than rupees 80 lakhs. He is saying that its value is 20 lakhs, so you go for compromise. So the law is settled. Bank
What
is not
OTS? OTS. What is your prayer here? Let us see first your prayer.
Yes. We have submitted the OTS. Dated 19/12/2000.
Issue a rule to so cause should not be issued directly to dispose of the representative for settlement of loan account.
Without disposing, they hold our
already rejected.
Hold our representation for 6 months. And without
Now this,
disposing.
where is your representation?
Yes, representation is page number 15. That is the type copy. And page number 18.
Let us see 15.
Yeah, 15. With due respect, I beg to state that I want to settle 2 loan accounts amicably which are in the name of my son. Recently, my son had undergone a brain surgery in Astar Hospital, Whitefield, Bangalore. I regret to inform you that after the brain surgery of my son in the year 2024, the source of income were closed. As I failed to pay the installment in time, therefore the bank has declared the said accounts as NPA. The business of my son is totally closed now. We have incurred lots of expenses for brain surgery of my son, and doctor advised us that the prolonged treatment of my son will be required. Sir, my age is 71 years and I'm also suffering from various ailments. Few months earlier, I met with an accident and for that my leg was badly injured and now I won't be able to do any kind of work. I have annexed all the medical certificate with this application. Sir, my son has availed the loan by mortgaging our residential house, and the bank realized that the market value of the property is less than the outstanding amount, and the value of the property will be around 20 to 25 lakhs because the land is adjacent to the road, which is around 5 feet width. Sir, I do hereby like to inform you that due to my old age and prolonged treatment of my son, we could not generate any income, and now with great hardship, we have accumulated a sum of rupees 20 lakhs from our friends and relatives on interest basis. Now we have no capacity to pay more. Therefore, due to the above, these representations are duly received. That is page 18. Your offer is received on 19/12/2025. The same has been forwarded to competent authority for further discussion with analysis. Now they hold this 6 months, and now they have initiated the proceeding, surface proceeding. So why they hold this for 6 months? My prayer is for your lordship.
Firstly, with this representation you have come.
Yes, lordship.
For a direction to consider. Right?
Yes. Yes.
That please take 20 lakhs. I have accumulated. Right. Now, my first question is that whether this petition is to be entertained with the given set of facts.
No, lordship, thereafter we have again
Whether we
sent
can
one-
direct the bank to
No, no.
consider your representation.
No.
Huh?
No, this court has.
Yes or no?
No.
No.
But
Then-
but the thing is that my prayer is that they
If it is no,
hold it for 6 months. Why they hold it for 6 months?
for that also, whether with this kind of representation, whether you can approach the 226 court, that bank is not taking a decision about my offer of 20 lakhs.
But I have,
Whether, tell me,
but lordship, I have no other remedials.
what can I do?
If they hold this, if they're doing arbitrary thing, then where the borrower will go?
No. But it is not a court.
The DRT is not.
We have been barred.
DRT is only hearing the surface it.
That with an offer, you go to the bank that instead of 3 lakh, 30 lakh say, or 25 lakh, please take 20 lakh as a one-time settlement.
No.
Right?
Yes. This cannot.
And you come to 226 court.
Yes.
That please direct the bank for consideration of my offer. Or in other way, I have filed a representation, they have kept it pending for 6 months. What cannot be done directly? Can it be done indirectly? So far that auction notice is concerned, it is division bench matter.
Yes, sir. Yes.
We don't have jurisdiction.
No. But I have here, but they have hold this for 6 months.
What
So
to do?
we have accumulated the amount.
What to do?
Then bank can do anything.
My lord, it is already rejected by the competent authority anyway. Because the value of the property is around 80 lakhs. He is saying that it is 20
Yes,
lakhs.
hardship is okay. I can consider. But jurisdiction is most important.
But yes, sir.
The jurisdiction of the court. So far as hardship is concerned, this court is with the petitioner. But so far as jurisdiction is concerned, this court is not with the petitioner.
Yes, sir.
So, Mr.
So if they reject our proposal, they can
This is
refund the.
this
refund
is
the
the
amount.
indirect way of
Ah.
invoking jurisdiction.
Yes.
It will be difficult to enter in this petition because of specific 1, 2, 3 decisions of the Supreme Court.
The decisions are there, but.
Aurobindo Electronics, Biznor Urban Cooperative Bank
Yes, sir.
Limited, to be difficult. Heard, Mr.
Yes, sir.
No way. As does Learned Counsel for the petition. You have tried.
A Parvez.
A Parvez, Learned Counsel for all the respects. First of para. The petition has instituted the instant writ petition under Article 226 of the Constitution of India, seeking a direction to the respondent Canara Bank authorities to dispose of the representation submitted by the petitioner on 19/12/2025, praying for settlement of the loan accounts. Post of para. It is stated that the petitioner had availed two loans within bracket cash credit and housing loan bracket close from Canara Bank. Oh, you are okay. Where his father stood as a mortgager by mortgaging the landed property which belongs to him. After sanctioning of the two loans, the petitioner as the borrower was paying regular installments to the bank and also maintain regular stock. In course of time, the drawing power was also increased. In the year 2024, the respondent bank had acknowledged that the petitioner was maintaining good overdraft facility. It is the case of the petitioner that in the year 2024, the petitioner was diagnosed with brain cancer and had to undergo surgery at a hospital in Bangalore. He was admitted in the hospital from 29/1/2024 to 2024. So after the surgery, the petitioner has been regularly undergoing medical checkups, and as on date, he is not medically fit. In view of such health condition, deteriorating health condition, the petitioner could not pay the installments against the two loans regularly, and as a result, the loan accounts were declared as non-performing asset, NPA. After the loan accounts were declared NPA, a representation was submitted by the petitioner's father before the respondent bank on 19/12/2025, praying for settlement of the loan accounts Full stop. It was represented that by the petitioner's father that the market value of the property mortgaged how much is the outstanding?
Outstanding is now
69 lakhs.
60.
Oh,
But this is a
market
special
value of
amount.
the property mortgaged was less than the outstanding amount. And he had generated, he had collected a sum of rupees 20 lakh from friends and relatives in order to repay the outstanding loan amounts by offering a sum of rupees 20 lakhs. The bank authorities were requested to settle the loan accounts to the said representation. Full stop. Mr. Parvez, Learned Counsel appearing for the respondent bank authorities have submitted that presently the outstanding loan amount presently stands at around 69 lakhs.
69 lakh 49,000.
69 lakh.
It can be seen at page 29.
Okay. Page
29. Sale notice.
Which part?
In table second row, last line.
Table, okay, 69.49 lakhs. 69, 49, 000. And the bank has already initiated action under the provisions of the Security and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, read with Rule 8 within bracket 6 of the Security Interest Enforcement Rules, 2002, page 29. So in that connection, a sale notice has already been published on 8/6/2026 for auctioning of the mortgage property through online e-auctioning on 25/6/2026. Today. Post. He has submitted that any offer for one-time settlement of loan is not to be hesitated in a writ petition under Article 226 of the Constitution of India. First of para. I have considered the submissions of the learned counsel for the parties and have also considered the relief sought for by the petition in the instant writ petition in the form of a direction to the respondent bank authorities to consider the representation of dated 19/12/2025, wherein the petitioner's father had made an offer for settlement of the loan accounts at rupees 20 lakhs. First of para, it needs the relief sought for by the petitioner in the present writ petition is a writ in the nature of mandamus to the respondent bank authorities to accept the petitioner's offer made through his father by the representation dated 19/12/2025 for closure of the loan accounts by accepting the offer of rupees 20 lakh against the present outstanding amount of rupees 69,49,000. Close to para. Para 8. It is noticed that the Honorable Supreme Court of India, by its decision in so and so, State Bank of India versus Aurobindo Electronics Private Limited, Bijnor Urban Cooperative Bank Limited versus Meena Agarwal. Has considered the matters of one-time settlement and maintainability of a writ petition under Article 226 of the Constitution of India, seeking a direction for consideration of case under one-time settlement of a financial institution, bank, stroke bank, then 9 Bijnor State Bank of India. In view of such settled position of law, who are the relief sought in the writ petition? This court finds that the writ petition is not maintainable and is liable to be dismissed. It is accordingly dismissed.
Item 11.
May please your lordship. The matter is pertaining to bank account.
Mr.
NK Alam.
N.K. Alam, learned counsel for the petition, Mr. H. Chakraborty, learned counsel for the
Respondent 1, lordship.
respondent number 1. Okay, Central Government Council for the respondent number 1. Full stop. And Mr.
Respondent number 2, A. Hussain.
A. Hussain, learned counsel for the respondent number 2. So you get your instruction. In this petition, the petition has the petition has been maintaining savings bank account number 2 at Morigaon branch of the respondent number 2 bank. Full stop. It is a case of a petitioner that on the basis of a cyber complaint, the said savings bank account of the petitioner has been kept freezed since March 2026 without any prior notice stroke information to the petition. Issue notice returnable on so as Mr. Chakraborty, respondent number 1, Mr. Hussain 2, no formal notice, extra copies, 2 working days. The respondent number 2, learned counsel for the respondent number 2 shall obtain instruction as regards the reason for keeping the bank account of the petitioner in debit freeze condition. And if it is on the basis of any complaint, stroke cyber complaint, comma, then order any specific instruction regarding any suspicious transaction has been made, and if yes, to what extent?
12th August, 1208. Item 12.
May please your lordship. Item to similar issue.
Savings bank account 36595554216. Nobody present, steps. Bechamari branch, Nogao.
Yes.
Respond number 1. Wait, Mr. Chakraborty, you can accept. Union of India, you have no role, only here to appear. Mr. H. Chakraborty, learned counsel, Central Government Council for the respond number 1. Union of India. July 2025, debit freeze condition. Any particular amount?
Lordship,
No.
nothing has been provided.
Okay, same. Steps upon the respondent number 2 by speed post to reach working this.
13.
If the matter pertains to non-payment of compensation from APDCL, Your Lordship, due to the
Art
death of
Mr. B.J. Mukherjee, learned counsel for the petitioner. Power Department,
Yeah, I'm for the APDCL.
can you accept notice for Power Department?
Yes. No, not.
Okay. Miss M. Borman, learned junior government Assam for a respondent number 1. And Mr.
C. Paul,
C. Paul, learned standing counsel.
appearing on behalf of KP Pathak.
Okay, learned counsel on behalf of Mr. K.P. Pathak, learned standing counsel, APDCL for the respondent number 2 and 4. Oh, Miss Borman, Chief Electrical Inspector, 1 and 3. Police 2, 4,
2, 4, 5, 6, 7,
6,
8, and 8.
7 and 8. Okay. The petitioner stated that her husband comma Sukramani Rai
Lordship.
died on
21/19.
29/1,
21/9.
21/9/2023 due to electrocution. Also, the petitioner has stated that her husband got electrocuted by a high voltage electrical wire which was lying on the ground.
On the ground.
Lying on the ground.
Lordship.
Which was lying on the ground. Also, issue notice. The instant repetition is preferred, seeking compensation against such death by electrocution. Issue notice returnable on so-and-so. As Miss Borman 1 and 3 and Mr. Paul Moral, no formal notice. Extra copies, 2 working days. The respondent authorities in the APDCL and the respondent number 3 are to bring their stance by counter affidavits before the returnable date. The affidavit of the respondent number 3 shall deal with the electrical accident. So I'll have to deal with the issue whether any inquiry has been initiated or not, and if an inquiry has been initiated, then the electrical accident inquiry report is to be brought on record by its through its affidavit. The name of the government advocate Sam is to be reflected in the respondent side.
Much.
Yes, today. Okay, today. During the course of the day.
12th August, 1208. Item 14.
May it please. One of the petitioners herein, the resident of Tejpur, public drain is going in front of their house, my lord, which was the localities, all used water, dirty water, everything was coming in front of their house. So for renovation and putting a culvert, my lord, I noticed inviting tender was issued. Thereafter, work order is also issued. Now, my lord, after starting the work has been halted. For what purpose? Nobody
We can
knows.
issue notice, but pendency of the repetition shall not be a bar to dispose of the repetition. Only you can do that.
Or in the alternative, may dispose of to dispose.
But he is not here.
But
That municipal board is not here.
municipal board is not there. Representation I have filed.
So pendency of the revision shall not be a bar. That much I can do. Because the first prayer we can have only after their appearance. Yes, madam. Heard Mr. P.K. Roy Chaudhary, and Senior Counsel, State by Ms. Learned Counsel for the petitioner. Petitioners. Ms. Bormon, you are for one or?
1 and 2, my lord.
1 and 2. Ms. M. Bormon, Junior Government Advocate Assam for the respondent number 1 and 2. Full stop. The petitioners have raised a grievance regarding a common public train running along with a public lane, which is across the road and in front of the house of the petitioners. Full stop. The petitioners have raised a grievance that because of halt, because of slow progress in the construction of slab covered RCC drain with culvert, comma, the petitioners are badly affected because of the garbage, comma, filth, comma, untreated sewage and dirty water discharged by the public, dirty water discharged through the said public drain, which in turn overflows the private drain and enters a private drain of the petitioners and enters inside the boundary, their boundary. Full stop. The petitioners have stated that they have submitted a representation before the respondent number 3 on 17/3/2026. Though the said receipt of the said representation was duly acknowledged by the respondent number 3 on 18/3/2026, no discernible steps seem to have been taken by the respondent Tezpur Municipal Board authorities to redress the grievances of the petitioner, hence the repetition. Issue notice returnable on so and so as Ms. Bormon appeared accepted 1 and 2, steps upon respondent number 3 and 4 by speed post within 2 working days from today. Pendency, it is observed that pendency of the repetition will not be a bar for the respondent number 3 and 4 to consider and dispose of the representation dated 18/3/2018, dated 17/3/2026. On its own merits.
Obliged.
Item number 15.
My lord, I am the owner of a plot of land measuring 1 kata 1 lesser. And out of this 40 lessers is situated within the number
1 kata
1 lesser, my lord.
1 kata 1 lesser.
1 lesser, my lord. Out of this
Krishna Hazarika.
14 lessers of land is situated within
14 lesser?
14 lesser is within That number 554, again, pattern number 340, my lord. In this land, one biscuit factory is there. And another 7 lesser is situated again, that number 26, Exona pattern number 6. And these lands have been evicted due to the development of.
I'm not understanding your case. Let us see the documents, or where is your environment?
My lord.
You are Krishna Hazarika.
My lord.
I'm owner of a plot of land. 554 KP Patta 340, 14 lesser. And one Exonia Patta.
Exona patta bearing that number 26.
7 lesser.
7 lesser, my lord. I have, due to the development.
14 lesser plus 7 lesser, 21 lesser.
21 lesser, my lord.
And you have 2 katha, 1 lesser. What?
My lord, some print in the synopsis, so some printing mistake. In the synopsis, some.
I go by synopsis.
My lord.
What kind of synopsis you have made?
Oh,
It says
some
Kali
printing.
Mandir, but in the pleading, it says Shiva Mandir.
Shiva Mandir, Kali Mandir, two mandirs are there. That's why in the petition.
Your synopsis, the first paragraph itself is very confusing.
My lord, this is some printing mistake because it has been checked by the junior staff.
No, that you cannot blame the junior. You have to own the responsibility. Then what is in the body, Mr. Das or Talukdar? Any
Lordship, kindly see the prayer.
confusing?
Lordship, kindly see the prayer, Lordship.
Land documents also.
Page 11, Lordship. Commanding the respondent authorities to stop further eviction on DAG number 554, KP number 340, plot of land petitioner making any notice. Lordship.
554, 340.
Yes,
Okay.
Lordship, I have specific instruction, Lordship, in respect of this DAG number, Lordship, that land is outside the ROW, right of way, Lordship. So that land is not required, Lordship. Why is Lordship approaching Lordship?
My lord, within this, the number 554, my lord, one district factory is there. And now,
Is it in the notice?
but I have not received any notice, my lord.
No, why? It is not within the right of way or not within the process of acquisition.
No, my
Then
lord.
why no notice?
My lord, I have not received any notice.
And in
Not required. It is not to be acquired.
Yes, Lordship.
Why to XYZ who are not within the purview of acquisition, notices are to be issued?
Yes, no,
No, my lord, but due to absence of these authorities, but they have not acquired.
What instruction you have?
Lordship,
Connection
on
line, my
presumption,
lord.
Lordship, there is no any.
3A notification, is it there?
Yes, Lordship, that land is not included, Lordship. And Lordship, in respect of DAG number 43, that is government land. And Lordship, he has received some amount, Lordship. Zirat compensation received, Lordship.
My lord, again, page number 31, 30 and 31, for annexure number 9, it has been mentioned that due to the absence of the authorities, the land has not been measured to where the biscuit factory is situated. My lord.
That land is not recorded.
Mr. This is 26.
My lord.
DAG number 26.
26. That is
Your
also,
prayer
Lordship,
is DAG number 554 and 340.
My lord.
that DAG number 26 also not affected, Lordship.
No,
Biscuit factory is there, my lord.
No, Mr. Das. Mr. Das.
Yes, sir.
First you come to the prayer. Page 11.
My lord, 554.
554 and KP Patta number 340.
340.
This is, according to you, KP Patta means it is periodic Patta land.
My lord.
This KP Patta 340 DAG number 554, according to Mr. Talukdar, is not going to be acquired at all. So meaning thereby, it is not to be disturbed. Right?
My lord,
Again, DAG number 26.
My lord.
Zirat.
Yes.
It is not a prayer in this writ petition.
And 26 also not affected, Lordship. It is within the line of the acquiring, but it will not affect, Lordship. That is also.
My lord, again, annexure 9, page number 30, 31.
Yes. বাদ পৰা জিৰাত জৰীপ কৰা সন্দৰ্ভত প্ৰতিবেদন প্ৰেৰণ.
My lord, I have.
Read third line.
Yes, my lord, I have not received any compensation of Zirat. But here it is in this.
Your biscuit factory is not going to be demolished.
My lord, they will be able to the same within
This is my instruction
the
also, Lordship.
Huh?
This is my instruction also. We have written a letter to the circle officer, Lordship. After this also, they are constructing new construction, Lordship.
Expecting
No, already constructed, Lordship. That is why we wrote the letter.
widening of
Krishna Das ne Krishna Hazarika. Krishna Das se hacho. Krishna Das. Lekin documents e diya nahi. Das Hazarika to appeal kena hoga na. So the dictation algo list.
पता तो
सारी ऑफिस अपना मिला हुआ नहीं याद है कृष्णा हजारिका लेकिन इसलिए तो कृष्णा हजारिका कृष्णा
No, we are concerned with DAG number 554, KP pattern number 340.
Yes.
Because
Yes,
this is the prayer.
Yes, Lordship. No, he's just now submitted that he had not received anything. He's just now submitted that he had not received anything, Lordship. He has received, Lordship.
Page 14 also can leave it look up.
Yes, Lordship. In the Assamese version, it is Krishna Das, and in the type copy, Lordship, he has written Krishna Hazarika.
Yes, Krishna Das. Krishna Das and Krishna Das is the same.
Sometimes he used to write Krishna Hazarika, sometimes he used to
One
write
and same
Krishna
person, my lord. तब ने
Kurmara Gaur, Axonia Pacha.
Mother name is
correct. Jerokom Milo. Goa dekha jay.
Consider নকৰিব
Suppression of material.
নাই না son of late Raji Hazarika. Page 3 and 14 Milot is completely different.
Rajiram Das.
Raji Hazarika, Krishna Hazarika, son of late Raji Hazarika. Here it says, my lord, Krishna Das, son of Rajiram Das.
Everything is so confusing.
My lord, I have not received any direct. What you been up my annex chapter 9, page 30-31. It has been written that I have received.
Mr. Das, Mr. Das, when your prayer is confined to DAG number 554 and KP pattern number 340, we'll only confine to that, right? We'll keep ourselves on the national highway only. We will not travel beyond national highway. This page 30 and 31 is beyond national highway, meaning thereby beyond the scope of the repetition. Come to page 11.
If additional, if the court grants the additional affidavit, maybe filed, my lord.
Mr. Right from first paragraph of the synopsis itself, everything is misleading.
My lord, it is some printing mistake.
Page 3 and page 14.
Printer do not commit mistake. Man commit the mistake. Right. Man types. Printer gives the outcome. Don't blame the printer. Yes.
Krishna Hazarika, son of
No,
late.
this prayer is that
Prayer is
Mr.
also
Kaluja
there.
is saying that DAG number 554 is not within the purview of petition. What?
Nothing refers back.
You have instruction.
Yes, Lordship. I have telephonic instruction, Lordship. That may be recorded, Lordship.
Get the 3D or 3-way notification and I will rightly dismiss it. If for Axonia Patta, he has some other claim, make him file other petition. Why should we keep this pending? Already 15 minutes spent. Get the 3A notification. Right now, I will dismiss. Today.
3A.
Because prayer is for DAG number 554.
Lordship.
Get the notification. That's all. If for Axonia, he has other claim, biscuit factory, let him file another petition. We will not expand the scope of this repetition. Get it?
My lord, the petitioner is a government employee, my lord.
You say 2000?
Lordship.
I heard Mr. M. Ali Learned Counsel for the petition.
Yes.
And Mr. N. Das Learned Junior Government Advocate for the respondent number 5. Also, the petitioner is maintaining salary savings bank account within bracket salary account number pair to at Gwalpara branch State Bank of India. Respondent number 4 bracket since 10/5/2023. The petitioner stated that since when?
February 2/2026.
Since 2/2026. The said bank account has been kept debit freezed without any prior information to the petitioner. Also, on inquiry, the petitioner has been informed that the respondent number 5, at the instruction of the respondent number 5, placed by a letter dated 8/6/2026, the said bank account has been kept debit freezed as there is a suspicious transaction of rupees 2,000 in the bank account. Post of. Any officer in charge, where is that letter?
But Annex 4. Officer in charge wrote a letter to the branch manager that no adverse evidence has been found against the petition. That is page
What is
15.
page 15?
Lordship, this is the letter issued by the officer in charge to the bank manager requesting him to defreeze the account. And it says, my lord, no adverse evidence has been found against the
The petitioner stated that on 8/6/2026, the respondent number 5 wrote to the respondent number 4 that the bank account was frozen in connection with a suspected cyber fraud transaction. And as per available records, an amount of rupees 2,000 is the suspected to be involved in cyber fraud transaction, stood credited to the account of the petitioner. Post of otherwise, no adverse evidence was found against the account holder, that is the petitioner, in any cyber fraud activity. The respondent number 5, by the said letter, the respondent number 5 requested the respondent number 4 to keep on hold the disputed amount of rupees 2,000 and to consider unfreezing and allow the petitioner to operate the bank account on the remaining, to allow the bank account. As the bank account has not been allowed to be operated by the petitioner till date, despite the letter dated 8/6/2026, the petition is before this court. Issue notice returnable on so and so. As Mr. Das for 5, no formal notice. Extra copy by tomorrow. Steps upon 1 to 4. By speed post 3 to working this.
Obliged.
Copy দিব এটাও
Seventeen. Item 17.
Part Mr. A. Konikor, learned counsel for the petitioner. Page, no page number.
Page number 63.
You have only paginated your petition, not the court's petition.
Ours also.
And Board of the Revenue 1. H. Sharma, additional senior government advocate for the
3, 4, and 5.
The petitioner may approach this court assailing an order dated 6/11/2025 passed by the Assam Board of Revenue in case number 71 RA within bracket and stroke 2025, whereby an appeal preferred by the petitioner under section 147 of the Assam Land and Revenue Regulation 1886 against an order dated 17/10/2023 passed by the respondent number 4 has been dismissed on the ground of limitation. Post of it is the contention of the learned counsel for the petition that the appeal has been dismissed by the impugned order dated 6/11/2025, which is cryptic and non-region order. Post of the period of delay in preparing the appeal was 5, 6, 7 days. Post of issue notice returnable on so and so. As Ms. Bordolo, Mr. Sharma, no formal notice, extra copies. Steps upon respond number 2 and 6 by speed post during to working this one today.
14th August, 1408. Item number 18.
Lordship will find the impugned speaking order at page 83. This is speaking order dated 14/06/2026. Whereas the Honorable Gauhati High Court in writ petition number so and so had directed the District Commissioner, Kamrup Metro District, to provide an opportunity of hearing to the petitioner, namely Dinesh Das. Whereas the District Commissioner, Kamrup Metro District, authorized the Co-District Commissioner, New Gauhati Co-District, by the order dated 9/1/2025 to conduct an individual hearing of the petitioner. Accordingly, the then Co-District Commissioner, New Gauhati Co-District, submitted his report by number so dated 11/3/2025. Whereas the government land has been reserved for TB hospital and the applicant Dinesh Das is an unauthorized occupation of the said land and has submitted an application for settlement. Whereas the inquiry conducted by the Co-District Commission, New Gauhati Co-District, concluded that the settlement petition of the petitioner is not admissible under the Land Policy 2019 and rules thereof. However, as the case had already been placed before and approved by the SDLC in its meeting held on 11/12/2020, the settlement petition of Dinesh Das was forwarded to the Revenue and Disaster Management Department, Government of Assam, for necessary instruction and further action in accordance with law. Accordingly, the Government of Assam by letter dated 23/12/2025 instructed the undersigned that the settlement proposal of Dinesh Das be placed before the SDLC for cancellation. Whereas said settlement proposal was approved only by the SDLC and had not been approved by the Revenue and Disaster Management Department, Government of Assam, the SDLC, EDLSC, in its meeting held on 12/6/2026, examined the matter and came to the following conclusion. The government land for which the petitioner has sought settlement has already been reserved for TB hospital. The settlement petition of Dinesh Das was erroneously forwarded to the Revenue and DM Department, overlooking the fact stated at point 1. During the hearing conducted by the Co-District Commission, New Gauhati Co-District, when the petitioner was asked to vacate the land, he could not produce any substantive document providing that
he had been residing or occupying the plot prior to 28 June 2001, which is mandatory condition for grant of settlement in urban areas. In the light of the findings recorded in point number 1, 2, and 3, above resolution number 294 passed in favor of the petitioner in the SDLC meeting held on 11/12/2020 is thereby cancelled. Now, Lordship, here it is.
Why 28 June 2021 is an important date? 28 June 2001 is an important date.
That is my learned friend can speak why it is. But Lordship, while SDLC has approved at page 24, entire documents were verified. Thereafter only the SDLC has by resolution dated.
This land is reserved for TB hospital when?
But
as per the land records?
As per the land record, it is as per the report of the circle officer, the land is outside the TB hospital. As per the report.
Where is the report? Where is your proposal first, SDLC?
Yes, 24. This is the type copy also.
The main copy.
Minutes of the subdivision.
Yes, CL number, resolution number.
Resolution number, so far Dinesh Das is concerned, 294, resolution 294.
294. Dark number 97. And petition number
255.
Yes. Where is that? Dark number 97.
97.
Where is the report?
Report that is here it is not annexed. In other petition we have annexed, Lordship, but here it is not annexed.
Why you have not annexed?
Now can we come to page 29?
Page 29.
Page 29. This is the letter from the Joint Secretary to the Deputy Commissioner Kamru Metro. In inviting a reference to your letter.
SDLC is one of the authorities in the hierarchy.
Yes.
But final decision making authority is the revenue department. Right. It is within the hierarchy.
Yes.
After SDLC, it will go to the revenue department. So revenue department approval is there.
But revenue department has written to the Deputy Commissioner.
So it has not accorded according to that order. Revenue department wrote that they did not accord any approval.
Yes.
Right. That page you said.
Page
83.
83.
1, 2, 3, 4, 5, 6, 7.
Yes.
7. Seven para.
Yes, sir.
23/12/2025.
23/12/2025.
For cancellation.
Yes.
Meaning that it did not approve.
It did not approve.
It
but
did not approve.
It has not been cancelled also. Lordship.
No. For cancellation.
For cancellation.
Instructed.
Instructed for cancellation. But we have
The
to-
meaning there it is negative.
Yes. Yes. Otherwise it is.
Revenue department has answered it in the negative.
Yes.
And ground number 1
Yes.
already reserved for TB hospital. When it was reserved for TB hospital.
That so far our so far the
Prior to your occupation or after your occupation?
after the occupation.
Okay. Then third point. Because point number 2 is answered by paragraph 7.
Yes.
Revenue department did not accord approval.
Yes.
Now third point.
Third point.
that he could not produce any substantive document proving that he had been residing on the plot prior to 28 June 2001, which is a mandatory condition.
Yes.
Mr. Borbujari can highlight why it is so important.
If I take your lordship to the annexure 9, page 87, this is the voter details of my father lordship.
Page?
Page 87.
87.
Voter list of 1966. We are residing here itself from way back from 1966, and petitioner number 2 has been residing.
Just a minute. Let me see first.
Yeah. This is the NRC, sorry, NRC details.
But this revenue received is DAG number 12.
That is old, lordship.
Birubari?
Yes, this is old.
Huh?
Old DAG number. Earlier it was 12, old.
Okay.
Now it is 97.
Okay. And this is revenue received of 1994. Okay, that is one. And what is the other one?
Other one is
Dinesh Das. The other document is GMC receipt is 2010 only.
tax.
That is page 95 is 2010 only. Page 95. GMC holding.
Yes.
2010 only. 93, 2000. Election letter. 2004.
Is 19.
So one revenue receipt is there prior to.
Page 89 lordship.
Village Digarupar is something else. Not Virubari perhaps. Page 88. Your NRC.
Yes, Lord.
Moza Panbari.
It is the father.
I don't think Moza Panbari. I am from also Ulubari Moza. It is from same. Panbari may be something different. Page 88 does not support any case.
At page 93, this is the voter details of the petition number 1. Page 93 is the voter detail of the petition number 1.
That is 2004. Which document is prior to that important date? On this one, page 92 only.
That 91?
92, DAG number 12.
Yes.
Birubari.
Birubari.
It is in the name of Dinesh Das.
Yes, this is of 1994.
Panbari Moza is different, Mr. Dhor.
His father was there.
Maybe in Panbari Moza, that does not mean that you.
No, I am only showing the legacy data.
Legacy, but page 92 is only the document.
Yes.
And this is, others are after 2001. Now let us see petition number 2.
At page 98, this is the GMC tax receipt of
which year?
1993. Oh, sorry, 1990, from 1990 to 91, and first is 1992-93.
Birubari.
Page 6, 1990.
Birubari.
Yes, sir. Then page number 100, 1993, tax receipt.
Land revenue, 1993. Yes. Yes, Mr. Borbudari. These are otherwise findings of fact. But whatever findings of fact have been correctly arrived at.
Now, Lordship has seen page number 92 of the writ petition.
92. Page number 92.
Petitioner is admittedly in occupation of government land. I am putting a question to myself. Can I pay land revenue for occupying government land? I will, at the most, I can only pay Dozi Bahira, fine. So this appears to be a manufactured document. This appears to be a manufactured document. Then, so far as my lord, that particular date is concerned, 28th June, that is to be found in my lord clause 14.4 of the land policy.
Okay, land policy, reaction 1989. Clause 4.
Clause 14.4, my lord,
14.4.
2019 land policy, my lord.
2019.
Yes, my lord. Clause 14, my lord, stipulates various conditions, my lord, which pertains to settlement and reservation of land in town.
Government policy and under government decisions prior to adoption of this policy. If found eligible, it would have been under continuous revisions since prior to okay.
Now, 14.4 is also subject to a condition that the person concerned will have to be landless, meaning thereby he may not. Lordship will kindly see the proviso, my lord, provided that persons having more than 3.5 acres of land in rural areas will, however, be not entitled to the above benefit. So this is only a policy. This doesn't have any statutory force. Nonetheless, my lord, these part and parcels of land falling under DAG number 97 were reserved for TB hospital way back in the year 1960. And
1960. Okay.
1960. And now that TB hospital has been renamed and reconstructed as the Pragjyotispur Medical College. That is the second medical college and hospital. Now, on findings of fact, there are clear findings of fact that he is not entitled for settlement. Speaking order is only limited to determination as to whether he is entitled for settlement or not. Only to that extent, nothing more, nothing less. And so therefore, my lord, at page number 15 of the writ petition, what has been put to challenge is only the speaking order. Page number 15 of the writ petition, my lord. Setting aside the speaking orders. They have not made any challenge with regard to any proposed eviction or whatever. It is not the case of the petitioner even. So at this stage, Lordship may be pleased to issue notice.
So this land, DAG number 97 was reserved in the land record since 1966.
Since 1966, prior to my lord 1970. Prior to 1970.
Prior to 1970.
Prior to 1970, and so far as my lord litigations pertaining to DAG number 97 are concerned, there were many litigations. The petitioners were, my lord, they were a part of a batch of writ petitions which have already been decided by this honorable court on an earlier occasion. But in those writ petitions, my lord, those
para 50.
Yes.
Para 50.
Yes, para 50. Thereafter, my lord, the speaking orders were passed with regard to 26 number of persons. 26 number of persons. In my lord, those persons who were a part of the writ petitions, my lord, analogous writ petitions in that order. Similar, identical speaking orders. Identical speaking orders. I can, my lord, with all conviction make that submission. Those speaking orders were put to challenge before this honorable court. Similarly situated. Coordinate bench of this honorable court, my lord, dismiss the writ petition. Put to appeal, my lord, before the honorable division bench, rejected. I have those orders. But nonetheless, if lordship may be please, issue notice, yes.
No interference.
Yes, yes.
Let us, you come back.
Actually, we will find a comprehensive affidavit on facts, my lord.
I'll also find an additional affidavit to bring on record the report of the circle officer.
Yes, yes, yes.
Heard Mr. R. Dhor, learned counsel for the petitioners. Mr. R. Borpujari, standing counsel, Revenue Department for the respondent number 1. And Mr. S.R. Burwal, learned junior government advocate exam for the respondent number 2 and 3. Post of. The petitioners have put to challenge 2 speaking orders. Both dated 14/6/2000.
And another is 15/6/2002.
Huh? Okay, dated 14/6/2026 and 15/6/2026. Passed individually against them. First of the operative parts of the speaking orders read as under page 83. Right here, but right here. Recording the reaching the above conclusions, comma, the respondent number 2 has rejected, has found that the petitions are not eligible for settlement of the 2 plots of land under reference, and they are liable to be evicted in accordance with law. Post of para. Mr. Dhor and counsel for the petition has submitted that they have sufficient document to establish that they fulfill all the conditions. They fulfill. No, they were in occupation of the plots of land from a date prior to 28/6/2001. Post of para. Mr. Borpujari and standing counsel Revenue Department has submitted that in respect of a number of similarly situated persons, speaking orders recording findings of fact had already been passed, and those speaking orders were put to challenge in a batch of writ petition, including WPC number
WPC 2128 of 2025.
So the writ petition, the said batch of writ petitions were dismissed
by my lord judgment,
by common judgment and order,
my lord 18/9/2025.
18/9/2025. Post of when appeals were prepared.
Yes, appeal was prepared.
The same common judgment and order dated so and so.
One of the leading
in read appeal number
311 of 2025
and others.
and
others
and
or one?
others. Yes,
And others.
and others.
Those appeals were also dismissed. And as such, post of making such submission, he has submitted that no interference at this stage is called for again, post of issue notice returnable on so and so. As Mr. Borpujari and Mr. Borua. No formal notice, extra copy you need to.
That read appeal was, my lord, disposed of by judgment dated, my lord, 27/11/2025. And so obliged.
The additional affidavit, no course of action process.
Oh, no. They all are dismissed thereafter. How can I? All are dismissed.
Nothing is going to be.
Mr. Dhor has sought for, has submitted that he will file an additional affidavit to bring certain more facts on record. The same is permitted.
1408, 14th August. Item 20.
Petitioner is aggrieved by the respondent number 3. The blanket breathes frozen on his account, my lordship. And there is no notice have been served to him, no complaint have been received from any corner from the any.
Mr.
Aramin, my lord.
Aramin learned counsel for the petition. Yes, madam.
For respondent number 4, my lord.
4. 5 also. This is a Ministry of Home Affairs entity only. Miss, your good name, please.
Jay Sharma.
Jay Sharma, National Central Government Council for the respondent 4 and 5. Post of the petitioner has been maintaining savings bank account number so and so at Borpeta Main Branch, State Bank of India, Union Bank respondent number 3. So it is the case of the petitioner that since when? Since
in the month of April, my lordship.
Since April 2026, the said bank account has been kept debit freezed without any prior information to the petitioner. Full stop. Any suspected amount?
My lordship, they have verbally informed us 11,000 rupees has been lent, my lordship.
On inquiry with the respondent number 3, the petitioner has been informed that the bank account has been kept debit freezed on receipt of a complaint regarding suspicious transaction in a bank account to the extent of rupees 11,000. Issue notice returnable on so and so as Ms. Sharma. 4 and 5, no formal notice. Extra copies within 2 working days. The petition shall take steps for service of notice. Upon the respondent number 1 to 3 by speed post within 2 working days. Post of the respondent number 4 is to apprise the court as to whether the bank account of the petitioner has been kept debit freezed on receipt of any complaint regarding suspicious transaction to credit in the bank account of petitioner, and if yes, the nature of the complaint and the extent involved, the amount involved, amount mentioned in the complaint.
12 August, 1208. Item 21.
Wait, please, Sir. I'm the owner of a plot of land which has been decreed in my favor, my lord. A appeal also filed by the respondent number 5 has been dismissed. But I went for execution, my lord. The executing court has held that since it's a decree of confirmation of possession, the court cannot come in. Now I went to construct a boundary wall. I was prevented by the respondent number 5. So I have filed an application before the authorities to demarcate the land, demarcate the boundaries. They have accepted, my lord, that it belongs to me. The date was also fixed, but now without any reasons, my lord, that has been kept in abeyance. My lord, I have come against that, my lord.
Okay. Yes. Mr. Ndeka, Learned Senior Counsel, State by Mr. And we will learn counsel for the petitioner, Mr. J. Tutia, Learned Senior Counsel and Senior Standing Counsel. Carpian Autonomous Counsel for the respondent number 2, 3, and 4. The petitioner has stated that he is the owner of a plot of land measuring 2 kathas, 17 lessas, covered by revenue tag number 110/158 and periodic patta number 106, situated at Bokolia Bajar, Moza Langpar, District Karbi Anglong, subject plot. The status of the petitioner as the landowner and his position has been confirmed by on the subject plot has been confirmed by judgment and decree dated 21/3/2023, passed by the Court of Munsif number 2, Karbi Anglong, in title suit number 7 of 2021, and subsequently, the same judgment has been affirmed by the Court of Civil Justice Karbi Anglong, title appeal number 03/2023, by judgment dated 31/8/2024, post of para. Subsequently, the petition submitted an application for demarcation of the subject plot post of on receipt of the application, comma, the respondent number 5 initiated a demarcation proceeding with by issuance of a notice dated 26/5/2026 by fixing the date, comma, 12/6/2026 for carrying out the demarcation post of, but on 11/6/2026, comma, the demarcation proceeding has been kept in abeyance until further orders post of agree by such action on the part of the respondent authorities, comma, more particularly, comma, the respondent of court, the petition is before this court. The issue notice returnable on so and so. Land revenue, okay, aforesaid revenue 1. Okay. As Mr. Assisted by S. Kemprai, okay, as Ms. Authorised and Ms. Kemprai,
2, 3, and 4.
1, 2, 1, Authorised, 2, 2, 4, Kemprai, no formal notice, extra copies. Steps upon, who are these 5 and 6 neighbors?
Neighbor, they are
Brother.
getting the problem. Brother.
Your brother,
My brother.
own brother,
Own brother.
5 and 6.
5 is the brother, 6 is the nephew.
Speed post. We didn't work in this from today. The respondent in the respondent authority, the KAAC, comma, more particularly, comma, the respondent of course is to bring his stand on affidavit as to why the demarcation proceeding has been kept in abeyance.
May I
On
make
the
a submission,
return.
madam? Pendency should not be a bar for them to carry out the demarcation.
Okay,
And my
it
lord,
is
can-
observed that pendency of the repetition shall not be a bar for the respondent authority, the KAC, to carry out the demarcation process, which has already
lord.
been stated to be initiated.
Till then can status quo be maintained, my lord, because I apprehend that the 5 may come into, and again, it will be a multiplicity proceeding, my lord.
5.
The respondent number 5.
Yeah, but should decree.
Again, multiplicity of proceedings, my lord. If he encroaches, my lord, again, I have to go under the section 6, my lord. If status quo is maintained, my lord, the respondent, no one is affected, my lord.
No. Demarcation proceeding. You are in possession, confirmation of possession.
I am in
So
possession.
why will multiply orders after orders on the subject plot.
No, my lord. What I am saying that if he encroaches, then it will rise to give rise to multiplicity of proceeding, my lord.
No,
Again, I
for
have-
that, it is not the private individual encroaching upon private individual land. This is not the jurisdiction of 226.
I am there, my lord. Which is correct.
Copy of the picture.
If Chutia encroaches, definitely I will order.
Definitely.
But it
Not
is
private
between
individual.
Between the brothers.
My lord.
1408, 14th August.
Yes, please, your lordship.
Yes.
Lordship, the disputed land is jointly owned by the petitioner and the private respondents because there is no partition or demarcation done for the respective share. The petitioner approached the,
Illegal construction.
yes, your lordship.
Response number 6. Will
Yes,
issue
Your
notice. Heard Miss
A. Hussain.
A. Hussain, Learned Counsel for the petition. Yes, Mr. Das and Das, Learned Junior Government Advocate Assam for the response number 1, 3, 4. 1, 3, 4. Who is this response number 5? Accountant. Why accountant is made a party?
By the treasury office.
Treasury officer should be made a party.
Treasury
He's a subordinate official. Okay, why he has been made party?
Because treasury challan have been paid, lordship, for this.
For that purpose, he is an accountant only. You are bringing an accountant who has issued the treasury challan. Don't make all of them parties. The petitioner has a grievance that the respondent number 7 has been carrying out construction in an unauthorized manner. So the
Lordship,
petitioner
respondent number 6.
as respondent number 6, the petitioner has submitted complaints before the respondent North Lakhimpur Development Authority on a number of occasions, including a representation. Which one last?
1912.
Including a representation dated 19/12/2025 was agreed by inaction on the part of the respondent number 2 Development Authority, not Document Development Authority, in taking steps in respect of the unauthorized construction carried out by the respondent number 6. The petitioner is before this court by the instant repetition issue notice returnable and so and so. As Mr. Das. 1, 3, 4. 5 also?
My lord.
Okay.
Treasury, yes. Treasury.
As appeared accepted notice on behalf of 1, 3, and 4. Huh? No formal notice. Extra copy you need 2 working days. Mr.
Treasury
Gogoi.
officer.
Mr. Gogoi.
Treasury office.
You are just for a namesake.
Treasury
Okay,
office.
B. Gogoi, Land Standing Council Finance and Finance Department for respondent number 5. Step 7, respondent number 2 and 6 by speed. 2 working days.
The decision from the my lord Neopsis, it seems it's in a totally my lord, it's in a civil proceeding should be there. Because my lord, the encroach,
Lordship, but illegal construction. is
Illegal
everything-
construction.
but prayer person, my lord,
Lordship,
demolish.
Lordship.
We may not accede to all the pairs. Let us see whether they have acted or not. Development.
Direction may be given to stop the illegal construction, Lordship.
Then I'll pass the order.
14th August, 1408.
Declining it.
Item 34.
Except treasury.
Yes.
The petitioners here and your lordship are in occupation of certain plots of land. Your Lordship. And in fact, the process for allotment has.
It's okay. You can issue notice on the prayers in the writ petition.
Lordship, only.
What apprehension?
The apprehension, your lordship, I have made a statement, your lordship, that since 2015, your lordship, they have not accepted our, your lordship, premiums, your lordship. And now when we went there, your lordship, to the office, they told that they are not going to accept verbally, your lordship, and said that there may be, we may have to, your lordship, vacate the land, your lordship. That
There
has.
will be notice.
But your lordship.
Notice already there is a set of
Lordship.
procedural safeguards.
Lordship, what has happened?
Just
No, your lordship will kindly see, your lordship. It is not the isolated case, your lordship. There are instances, your lordship, where the authorities, without hearing us, your lordship.
Will observe any the apprehension regarding so and so must be with due procedure of law, with a prior notice.
Only your lordship, that your lordship will do, or your lordship may. My prayer is that no coercive
There
case
is
should be taken.
already a procedural safeguards put in place.
Lordship.
But if you have an apprehension, we can only observe that why you are putting this in order, judicial order, that eviction.
No, your lordship, that is what has been told to them in the office.
Okay.
That is the problem, your lordship.
Okay. Heard Mr. S. Borthakur, Lion Senior Counsel, assisted by Mr. K. Mohammed, Lion Counsel for the petitioners. aforesaid revenue 1, 2, H. Sharma.
3, 4.
Additional senior government advocate for the respondent number 3 and 4. First of the petitioner have stated that proceedings regarding settlement of the plots of land under occupation of the petitioner of plots of land, which are described in paragraph in the table in paragraph 3 of the petition, have been initiated long back, but the said proceedings till date have not been brought to a conclusion till date, despite the legitimate claims of the petitioner in support of such settlement.
Premium has also been fixed.
So,
Your Lordship.
It is stated that the premiums for settlement of those plots of land have also been assessed. Despite approaches made by the petitioners to bring the entire process of settlement of the said plots of land to a conclusion, the respondent authorities are dilly-dallying the entire matter. First of, it is in such fact situation, the petitioners have an apprehension that they, the respondent authorities are in contemplation of eviction of the petitioners. Of those
Eviction, Your Lordship.
or coercive action.
Lordship, coercive action.
Okay. Are in contemplation of taking coercive action against the petition. First of, Mr. Authorised and Mr. Sharma have submitted that the petitioners have not placed any material as regards such apprehension. The matter would require consideration, issue notice, returnable on so-and-so, as so-and-so appeared accepted notice on behalf of so-and-so, no formal notice, extra copies within 2 working days from today. As regards the apprehension raised by the petitioners as regards coercive action, comma, it is observed that if the respondent authorities contemplate any coercive action against the petitioner, then any steps taken by then such coercive steps must meet the procedural safeguards and as per due procedure.
14th August, 1408. Item 35. Yeah, please. Your Lordship.
Seeking reimbursement.
Yes, seeking reimbursement.
Lordship notice.
Lordship, we are eligible for reimbursement because there is an eligibility certificate which is at page number 61. And thereafter, we have also got the certificate of entitlement, 100% SGST amount. But what has happened, Lordship, after a circular which is at page number 64 issued, the system has become online. So thereafter, we have submitted multiple representation to the authorities that we are not able to file our for reimbursement. We are not able to apply online, but the representation was not disposed till date. That's why I am before this all.
Immediately after the vacation, let me have the instruction.
Okay.
On 17th,
17.
yes.
Okay.
Will it be in the motion itself?
Will issue notice. Heard Mr. aforesaid learned counsel for the petition and Mr. B. Gogoi learned. Okay. Standing counsel, Finance and Taxation Department, Government of Assam, for all the respondents.
All the respondents.
The petitioner has stated that it is eligible for reimbursement of 100% of the net as GST paid in cash during the eligibility certificate on the strength of the certificate of entitlement dated 7/12/2024. Though the petitioner has submitted applications for such reimbursement in the offline mode. Offline,
We have
physically.
because the system has become online, so there is no offline method.
Okay. Though the petitioner has made endeavor to submit the application for seeking reimbursement, seeking reimbursement, comma, the petitioner has not been able to make such application for reimbursement in terms of the circular number 181, 2024, dated 21/10/2024.
Yes.
It has not been made possible due to what you say, portal.
Yes, because the way we have filed a tax is through GST DRC 03 application. So the portal is not accepting that. It is showing nil.
The designated portal is not accepting such application. Issued notice. Minister Gogo has submitted that he will obtain instruction in the meantime. Issued notice returnable 17/7/2026.
Let it be 20th.
20.
Not see, pendency should not be barred if they.
He'll come up with instruction. Mr. Google will also be not there in the vacation. So, as Mr. Google has appeared accepted for all the respondents, no formal notice, extra copies to all.
Item 36.
Your Lord. Petitioner authorized forest dwellers. Authorized forest dwellers.
Authorized forest dweller, very difficult term.
This matter is to be argued by the arguing counsel, Mr. P.N. Goswami. He is on his leg before court.
Okay.
The matter be fixed at 2, my lords.
Not 2, after 2.
Today.
Item 37.
But my brick kiln, my lords, has been shut down. The notice is at page 17. In fact, my lords, the only ground given is that I am manufacturing bricks of a different make. The notice, my lord. On the same day, my lords, my brick kiln was shut down.
I agree that Sanko Matham.
It is here, my lord. Biswanath Brickfield.
Page?
17. The notice dated 18/5/2026, my lord, which I received from the circle officer, Biswanath Revenue Circle.
Yes, Mr. Das. Or Ms. Burma.
Lordship, notice may go.
But they may take instruction if they have anything relevant, my lord.
But
Time limit is very.
I would have Mr. Don't praise.
After the vacation, my lord, but my lord,
after vacation.
the difficulty arising is.
Privacy without jurisdiction, but I cannot. Had it been not 7 days before vacation, I would have asked you within 2 days, but it is not possible. Heard Mr. A. Ganguly learning. So it is reasonable from your side.
Take the instruction instead of filing it.
A. Ganguly, learned counsel for the petitioner, Ms. M. Borman, junior government advocate for all the post of the petition is petitioner runs a brick clean.
Yes.
Brick clean.
Brick kiln.
By the name
Biswanath Brickfield.
Messrs. Biswanath Brickfield at village Dholi Kherwari, Silo. Moza Sakamotha, on Silo, Jila Biswanath, page 16 of Silo. So the petitioner is aggrieved by a notice dated 18/5/2026 issued by the respondent matrix, whereby, all on a sudden, the brick clean has been closed on the premise that the brick clean is manufacturing bricks of other mark than its own, then in its own name, Bishwanath Brickfield, BBF.
BB,
That is your,
that is.
okay. Fair enough. Mr. Ganguly has submitted that the response number 3 lacks authority and jurisdiction to close a brick lane in such manner. Ms. Borman has submitted that she needs some time to obtain instruction as regards authority and jurisdiction of the respondent number 3 to close a brick lane in such manner.
Respondent number 3's notice states about an order of the respondent number 2 district commissioner. If your lordship will kindly have.
Okay. As the notice dated 18/5/2026 has made a reference of of an order bearing number so and so dated 7/5/2026 of the respondent number 2, Ms. Burman shall also obtain instruction as regards the said letter number so and so and a copy of the same. Issue notice returnable on so and so immediately after vacation.
17th.
As Ms.
17.
Burman has appeared.
1707.
The pendency may not be a bar if they have a change of heart.
It is observed the pendency of the petitions and not be a bar. What? To recall? That cannot. I cannot make
No,
any.
they are-
Recall,
they-
sequel, whatever. You file representation.
Lodge,
Just my
lodge.
necessary.
I have already filed the representation. They are not answering.
That indication should not be there in an order.
They may have a change of heart, my lord, during the vacation perhaps.
Pendency of the petition shall not be a bar for the petitioner to submit a representation, press representation.
For reopening, for reopening the brick kiln.
For reopening of the brick lane.
Sure.
If such an application is filed, representation is filed, okay, shall not be a bar for so and so.
Public.
Supplementary list, item 32.
No more order.
One, three.
The copy of the letter number so and so of principal so and so placed by Mr. Gogoi is to be kept with the case record. You furnish them copies, Mr. Sharma. Copies of the repetition.
Yes, sir.
Item 15.
Just how many long? How many material? Just material. No. Yes.
Lordship, 3A and 3G notification.
Not included.
Not included.
Where is the council? Let him come. Okay, after some.
Lordship.
Supplementary list, item 38.
Lord, the petitioner has been declared as a willful defaulter, my lords. So entire proceeding is prejudged. She will kindly have page 31 for a minute, which is the initial show cause notice.
No, sir. Huh?
Wait, please, your lordship.
Yes.
Lord, now, my lord, the petitioner has been declared as a willful defaulter. My lord, there is a process for declaring the willful defaulter. The documents that I have placed on record, my lord, the initial show cause notice is issued on 16/9/2025. Lord, you will kindly have for a minute, page 31.
Page 31, I am looking at
Yeah.
page 31.
This is the initial show cause notice, and here I am told that, my lord, the identification committee, which is the first step. Let us say, my lord, there are two committees, the identification committee and thereafter the review committee of the bank. The identification committee informs me that I am proposed to be classified as a willful defaulter. And this is the material, my lord, which is there, which your lordship will find in the box. That is the reasons for willful default. And this is as per the stock statement dated 30/04/2025 submitted to the branch. Value of stocks was rupees so and so. However, on the branch visit, the unit on 17/7/25 was found that the unit is closed and stocks are not available. You have disposed of the stocks hypothecated with bank under the sanctioned paid facility without obtaining prior written permission. Further, the proceeds from the unauthorized sale were not routed to the OD account maintained with our bank. The act reflects a deliberate attempt to divert funds. So in view of the above, you are coming within the purview of willful defaulter as defined upon the above RBI master direction. Hence, the Committee for Identification of Willful Defaulters of our bank proposes to recommend to review committee of the bank to classify you as willful defaulter and report to the credit information companies. If you have any submission to make in this regard, same may be furnished. So, my lord, 21 days time is given. Now, my lord, my reply, which I have given, is at page 42. But your lordship will for a minute have page 41. This is the stock statement, my lord, which was furnished on 30th of April. My lord, the signatory is one of the four partners of the firm. I am not that partner. This is by one Pranay Kumar Saha, who is admittedly one of the partners of the firm. He appears to have submitted a stock statement. And later, my lord, 3 months later, when they go and when they see the unit is closed because the unit is running in NPM. In 2025, the bank has approached the DRT. Now, if your lordship will see, my lord, the page 42, this is my detailed reply through my advocate, my lord, which I have given as to why I should not be classified as a willful defaulter. Now, my lord, this reply was responded to by the bank by the communication of 9/12/2025, which is at page 48.
Page?
48, annexure 3.
Yes.
So this is, my lord, they have rejected everything. And at the end of this representation, my lords, if your lordship will kindly have page 52, which is the sort of operative part, my lords. If I may read, my lord. Further, on a perusal of your reply, it is observed that you have not provided any concrete submissions to the reasons stated in the show cause notice as to your actions which form the basis for concluding willful elements. In view of the same, the matter shall be placed before the competent authority to take appropriate decision in the matter. This reply is issued without prejudice, so and so. So this is the, my lord, rejection of my representation. And this is, your lordship will find, by signed not by the committee, but by an overseeing executive of R&L section circle office somewhere in Gauhati. It is not the identification committee which is supposed to deal with it. You know, the identification committee has to pass at least some reason, some semblance of reason, my lord, to my representation, because that is what the RBI requires. But I have only received this, the 9/12/2025. Even the designation of this person is not clear. And whether the minutes of the identification committee decisions, nothing is there. Now, if your lordship will kindly have page 53, which is the next page, my lord. This, my lords, is the proposal of the Committee for Identification of Willful Defaulter. This is dated 7th of January 2026. Now, my lords, if I may just read this notice, my lord. This is to bring to your notice that the Committee for Identification of Willful Defaulters of the bank has recommended classifying you as willful defaulter to the Review Committee of Willful Defaulters of the bank on 15/9/2025. Since the Committee for Identification of Willful Defaulters is not convinced with the submissions made by you. Pausing for a minute here, my lord, they have already recommended on 15/9. They are issuing me a show cause notice on 16/9. Absolutely, my lord, this is arbitrary. This is absolutely predetermined.
Which one?
Well, this proposed, the very forwarding of the proposal by the identification committee, which is there in 7/1.
This page 31 was when?
This page 31 was on 16/9/2025.
16/9/2025.
And here, my lords, in the 7/1/2026, this is the notice which has informed that my name has already gone to the, my lords, review committee, that they are saying that on 15/9/2025 already classified you, since the Committee for Identification of Willful Defaulters is not convinced with the submissions. Not my submissions were convinced were submitted on 15/10. Notice was on 16/9. The very forwarding
notice.
Well, there is one aspect of the matter. Willful defaulter, if I am declared, my lords, it's a
may
civil
be a
death.
typographical one also. If I examine your petition
Lordship.
thoroughly, there might be 10.
Lordship. Well, one aspect of the matter. Willful defaulter is a civil death, my lord. Supreme Court says so. The order declaring me as a willful defaulter, that may be suspended. Otherwise, my lord, they will publish it to the RBI in the Indian Banks Association.
There is only ground 15/9.
No, there are more, many more.
At this stage, we are issuing notice because final decision is not taken.
No, final decision taken, my lord. I'll come to the final decision. Lordship will kindly have. This is the final decision, my lord. Lordship will see page 67, my lord. Page 67. Review committee has also decided. This is 2nd of June, 2/6/2026, my lord.
So that 15/9/69 is the business.
59/69, and lordship will kindly have.
What more? We will not sit in appeal.
No, I'm not saying that.
So far as notice was given. But only thing is that you said that it was decided with a bias mind.
Pre-decided.
That is the only date you have shown
Yes.
us, 15/9.
15.
And notice was issued thereafter.
Thereafter.
So with a
So there is-
predetermined mind,
Predetermined.
by
And-
review committee had earlier taken a decision.
No, identification committee. Review committee
Whatever,
decision is
identification committee.
Yes.
And thereafter the notice is issued.
Thereafter, and lordship will for a minute will have a look at this order of the review committee. How this order has been passed, my lord. Page 67, my lord.
We are not into the decision, only
No,
the decision
only
making
the
process. sir.
Process. Only I'm on.
Only the process. That
Only the
process
process.
you have indicated, we will examine that.
And for a minute, lordship will kindly have these two pages, and then I will rest my case.
Sufficiency of reason or inadequacy of reason is not
But
the.
that is the part, no reason at all. Lordship will kindly see, my lord. This notice is issued to inform you that the review
Page?
committee, 67, Annexure 12. This notice is issued to inform you that the review committee for willful defaulters of the bank has classified you as willful defaulter on 25/5/2026 for the reasons mentioned in the show cause notice referred to above. The name of the company, borrower, so and so will be communicated to credit information companies to update in the list of willful defaulters. This is the, my lord, drastic step. And lordship, my lord, will see they have enclosed what? The extract of the orders of the review committee. That is at page 68. This is the one-page extract one. This is the order on the basis of which my name will be sent to the RBI, to the Indian Bank Association, to the credit information companies now. And I'll be blacklisted for 5 years, no finance, nothing. Recovery proceeding is a separate thing. They have approached the DRT, they may go under SAFSI, whatever.
Well, yeah, you should notice at this stage.
This order has to be stayed. Because otherwise, my name will be going to the RBI and the credit information companies. But prima facie, there is a, this is wrong.
Well, note your 5969 business.
No, not 59, page 67, 68. This is the order. This is not the way. Even the composition of the committee is not there. The review
Okay,
committee.
lack of jurisdiction, wrong constitution of the committee will examine that.
Lordship. But in the
But
meantime,
this is a matter which is to be responded also
yes, that is there.
by the bank.
If my willful defaulter is stayed, what
I
prejudice
am
they
not
will-
staying, making it clear. If you make your submission on interim prayer further, I'll decide.
Lordship. No,
I'm making it clear.
Lordship. My only humble submission is
No long cut, shortcut.
Lordship. To cut things short.
We'll issue notice also on the interim prayer.
The only till the next date, they may not communicate to the.
I'll decide. I'm
That-
making it clear.
That is there. That
Shall I decide?
My only humble submission is this, that they are proposing to do in page 67. That my name will be communicated to the credit information because I will be stopped.
Okay, it
in
will
5
take
years.
time, but I'll decide then.
Lordship.
I have made my
I understand it.
view clear
But my
at this stage.
Lordship.
So we will press for interim order. I have to decide.
Then
You take both the.
a short date after the vacation, if I may.
I can give it. I can give notice, but this has to respond.
No, they have to respond, no doubt.
Right. Traversing all the allegations you have made in the writ petition.
Lordship.
Right.
My only.
We can decide
The
the
only
writ
thing is
petition
that
itself.
the
Since
pay-
it is a case of
Lordship.
civil death, we'll
Civil
definitely
death.
decide.
Yes.
Give it a priority, but as on date, I don't think it is the case for
The difficult-
staying the.
No, the difficulty will.
That is the final interim order, which amounts to final relief, which is not to be stayed.
If they present the record before Lordship on the next day, that may be.
We will not
vacated.
go through records. Why should we go through records? Let them respond. If you have
If they.
asked your grounds in a clear manner, let them respond. Thereafter, we'll find out whether their response is insufficient.
My name will be put in the list of willful defaulters in the credit information company. That is the difficulty, Manoj. Only till the next day,
We can't help
that
it.
they may not do. Manoj.
No. Yes, you are appearing.
Yes, Lordship, I'm appearing for the respondent bank. Lordship, we have not received a copy till yet.
There is no standing counsel.
Standing heard Mr. A. Ganguly, learned counsel for the petitioner. Also, Mr. A. Hussain,
Yes.
learned counsel, has submitted that he has appeared on instruction for the respondent number.
Respondent bank.
Three.
Yes.
First of, he has however submitted that he is not in receipt of a copy of the writ petition and the annexes, first of para. In this writ petition, the petitioner has assailed a show cause notice dated 16/9/2025.
No,
Which-
I have not challenged the show cause notice. I have challenged the consequential order.
Your page 27 is that only.
Base is that, but the fruit melod is 2-6. That fruit I have challenged.
Okay. A decision taken by the respondent bank authorities on 2/6/2026, whereby the petition has been declared as a willful defaulter pursuant to a show cause notice dated 16/9/2025 and a notice dated 8/1/2026. First of, Mr. Ganguly has submitted that the initially, a show cause notice was issued on 16/9/2025. Asking the petitioner to show cause as to why it should not be petition should not be classified as an willful defaulter and should be reported to credit information companies. Post of in response to the said so-called notice, the petition submitted its detailed reply showing justification as to why it should not be declared as a willful defaulter. Post of. However, on 7/1/2026, a proposal was placed by the Committee for Identification of Willful Defaulters. Oh, no, sorry, by another notice dated 7/1/2026, the Committee for Identification of Willful Defaulters asked for any objection to the recommendation made by the committee for classifying the petition as willful defaulter to the Review Committee of Willful Defaulters. Post of in the said notice, it was mentioned that the Committee for Identification of Willful Defaulters recommended to classify the petition on 15/9/2025. Post of Mr. Ganguly has thus canvassed that the decision to classify the petition as a willful defaulter was already taken on 15/9/2025. That is, prior to issuance of the show cause notice, before classification as a willful defaulter on 16/9/2025. Post of. He has contended that the respondent bank authorities had proceeded with a predetermined mind to classify the petitioner as a willful defaulter, and as such, the entire action leading to the impugned decision dated 2/6/2026 is illegal and arbitrary. Moreover, most of the decision appears to have been taken moreover from the letter dated 7/1/2026, the decision seems to have been taken by an authority who lacks authority and jurisdiction to take such decision. These are the grounds.
And 2/6.
2/6. He has further contended that 2/6, the decision dated 2/6/2026 is not, does not contain any reason and is a non-speaking order, is a cryptic order, which is not sustainable in law. Issue notice returnable on so and so immediately after application. Notice is also issued on the interim prayer as Mr. Hussain. 1 to 4. No formal notice, extra copies by tomorrow. Steps upon 1 to 3. Steps upon respondent court by speed post within 2 working days from today.
17 July. Item 39.
May it please your lordship. This petition has been filed against the demolition order passed by GMDA. Impugned order at phase 49.
20?
49.
49.
Phase 49 is the last one. This is the demolition order passed by the GMDA. To be scheduled on 6/7/2026.
Yes.
My lord. Kindly may peruse page 39, my lord. Page 39.
Is it not an appealable order?
No, he has not he has suppressed the fact that appealable order has been suppressed it, Lordship. So that appealable order he has suppressed. He has what he is challenging is the execution order. That too after the court's order, my lord. Lordship, we recall, my lord, on 19/6/2026, my lordship had passed an order, my lord, that it was not executed. Then the next day, then the subsequent date has been fixed on. That is now is on 6/7, my lord. If lordship stand to page now 44, my lord, alia order dated 2/3.
Oh, that another writ petition.
That another writ petition for not implementing that. Alia order dated 2/3/2026, my lord. There is already that.
Where is that order?
Page now 44, my lord.
44.
First line itself, there is an order, a final order dated 19/11/2026. That has not been placed in the court, my lord. In continuation, the order passed by the authority, number so and so, dated 19/11/2025. That is the number, my lord.
That is the original order.
That is the original order. That is an applicable order. Section 71 of the GMD Act.
Yes.
And that is not been placed before the court, my lord. That has been suppressed, my lord.
1911.
1911.
So these are consequential orders.
This is a consequential means execution order. Since we have not done it earlier, on 2/3/2026. My friend appeared in the earlier case. He has pointed in the order that. This is the order that is appealable.
18/6.
And the copy is marked to the petitioner, my lord.
So, sir, where is the original order?
My lord, about 19/11/2025, I
Yes.
have not, that copy is not served to us, my lord. That copy was not served to us. We have served, my lord, order dated 2/3/2026. That is also a demolition order, my lord.
These are execution order. Because it says page 44,
My lord.
passed by the authority 19/11/2025.
In the copy, my lord, last in the bottom portion, that order, my lord. Copy is getting to the petitioner, my lord.
Appealable order is 1911. You can prefer an appeal as per section 74.
71.
71 of the GMD Act. And will not enter into disputed questions of fact before the district judge.
My lord, the entire.
I have passed number of orders.
Not the number of order.
And that authority has power to condone delay also.
Not right. The district judge can condone the delay, my lord. There is
Because
30
he is
days
a civil
within-
authority.
30 days time.
He is a civil authority
Not
otherwise. Not a order. And if you have not got copy of the original order, I can request Mr. Bora to furnish you a copy by tomorrow. But I will not stay this order. You get a stay on original order by filing an appeal. Otherwise, I have passed an order, in fact, to execute the order.
Yes, my lord. I have just given it.
Yes. In the other writ petition.
My lord, other writ petition is also.
I do not want myself to be contradicted by my previous order.
No. Now he is showing that what he is annexed earlier, which was not executed, my lord, on the ground that there is model code of
That
conduct.
was taken note of.
That is not.
That was taken note of.
Earlier writ petition, we are not aware, my lord.
That is whatever, then file appeal or seek review.
My lord.
I cannot sit on appeal over the earlier judgment passed in a writ petition by a court in advance. You can seek review or you can file appeal. But the original order is there. It is a consequential order. Original order is for demolition.
My lord.
And by this order, only date has been fixed.
But those notices.
Unless
those
the
of-
original order. Say, because it is complete, marked to you, page 44. If you say and made submission before the court as an officer of the court, then I'll request Mr. Bora to furnish a copy of this order by tomorrow itself.
Well, in fact, there are more than 8-9 days. He can file an appeal.
So that is why,
Otherwise, he'll be.
that is why by tomorrow I can request, if you make a statement that you have never received a copy of this order, so that while opposing the appeal, Mr. Bora can show from record that you have got the copy of the order.
May
What
provide
do you
today
say?
itself, man.
Huh?
May provide
Today is not possible, sir. 3 o'clock. Date is 6/7/2026. You have enough time.
By tomorrow.
Tomorrow. We'll close tomorrow.
What's-
We'll close tomorrow.
Well,
Right? You get the copy. I'll give you the liberty to file an appeal and also to seek for interim order. Heard Mr. A.K. Azad, a counsel for the petitioner. Mr. Petitioners. Mr. Housing also, your housing.
Lordship, Department of
Mr. S.
Housing.
Bora, Land Standing Council, Housing and Urban Affairs Department, stroke, GMD and GMC. For the respond number 124.
124.
Any panchayat?
Panchayat is there. He have to buy registered postman. Panchayat is there.
No, I'll fix it
Oh,
tomorrow only.
Yes.
And Mr. BP Bora, Land Council for the respond number
6 and 7.
6 and 7, first off. Mr. Azad has submitted that the petitioners were never been served with the order dated 19/11/2025. লিখি দিব number ECF so and so 19/11/2025. In passed by the respondent number 3, in consequence of which the order dated 18/6/2026, impugn industry petition, has been issued, full stop, by the order dated 18/6/2026. The date, the time and date have been fixed at 11 a.m. on 6/7/2026 for demolition of the construction, for removal to demolition of the unauthorized, alleged unauthorized construction, construction of brick boundary wall and houses constructed by the petitioners at Dharapur, Gauhati. Post of para. Mr. Bora has submitted that the copy of the order dated 19/11/2025 was communicated to the petitioners. Post of, be that as it may, he will place a copy of the said order tomorrow. The order dated 19/11/2025 tomorrow. Release the case accordingly on tomorrow.
In payment like that, page now 45, it goes to the page now 44, my lord. With the alia order, down below, we need copy to all the petition with the tick mark. That is
Yes.
also here the next, my lord.
Oh, yes,
Here's the
yes,
next.
yes.
Here's the next.
He was aware of that
He
also.
was aware of that also.
Okay, okay.
I am appearing on instruction as I.
Mr. Bora, so and so has appeared on instruction on behalf of respondent number
6 and
6. Tomorrow.
40. Item number 40.
Lordship, before my learned senior friend starts, Lordship, in this case, senior government advocate, he will appear. And he requested me to make a prayer before your lordship to Aisha.
May I please, your lordship? My lord, matter relates to eviction, my lord. My lord, what has happened? We are residing in a particular, my lord, ceiling surplus land, my lord. 5 bighas of all together land, my lord, of these petitioners.
Oh, same kind of notice.
My lord, notice had been issued. Along with the notice, my lord, what we have, my lord, challenge is that under the Mission Basundhara scheme, my lord, we did apply for the patta and issuance of allotment also, along with some other similarly situated persons, my lord. A section of the citizens, my lord, had been granted patta, but my lord, we had been rejected, my lord. That rejection order is also under challenge that we have been discriminated. Now, my lord, along with this eviction notice had also been issued as of late, my lord. After the rejection, my lord may be pleased to find.
First tell me, this is the first kind of notice or earlier notices were issued or some repetitions were filed by this
No, my
petition?
lord, as per my instruction, this is the first time we are now before my lord, my lord.
Yes, then this 67 notice was like yesterday's notice.
Yesterday's, my lord, I am not, my lord, disputing or controverting that these notices are different. This is same, my lord. But only one additional ground, my lord, which we have averred, my lord, that once in the same village, my lord, in the same area, a lot of citizens had been granted the patta. My lord, may kindly, I am troubling my lord.
Bring them on record then.
My lord.
Then only
My lord.
Article 14
My
can
lord.
be made operational regarding discrimination.
My lord.
Bring them on record, otherwise how
we-
can,
My lord.
then otherwise that if you want
My lord.
to have parity
My lord.
with certain other persons, according to you, who are similarly situated, they have been granted benefit and they have been treated beneficially, and you have been
Discriminated. Rejected.
hostile or whatever,
My lord.
then you have to bring them on.
No, my lord, we are not challenging.
Then this cannot be tested on that parameter. Only with you versus state can be tested.
Lord, with my limited understanding, what my humble submission before my lord is that, my lord, the state can also bring on record, my lord, that under what parameter and criteria they have adopted, my lord. My
No,
lord.
are you, but by this notice,
My lord.
as I have already
passed an order, my lord.
order.
Yes, yes, my lord.
So at this stage, that
Same.
procedure will not come.
Similar order, my lord.
That procedure will not come regarding threat of eviction.
My lord, that they are initiating, my lord,
Because I have already held yesterday.
My lord, what has happened, my lord, today those petitioners has approached, my lord, but they have said that the individual representation is required. That is
Yes,
they are asking. my lord.
Definitely.
My lord.
Definitely.
We are making that arrangement also, my lord. But my lord,
That is why yesterday I granted you time for 15 days
Yes,
to
yes.
file individual
Yes,
representation.
we are-
Other than this Masjid Kabristan,
My lord.
I indicated
No, we are so,
that
my lord. We
other,
are
how
so-
can there be justice
No, we
to
are
each
so
of the
obliged.
petitioners?
We are so obliged, my lord. My lord, only in this petition is that if my lord, gone through the records, my lord, then we can, my lord, demonstrate before my lordship that discrimination is there, my lord.
Okay, as on that, let this procedure goes on.
My lord.
We'll test your case
My lord.
regarding,
No coercive action may be taken against us
it
without.
is there in the notice itself.
My lord.
Why should I keep? Yes, we can keep that if
No, my lord,
if at a subsequent stage,
my lord,
the
if we are
respondents,
attempted to evict us, my lord, after
then
the
you can make a prayer.
my lord.
As on that, yesterday I have held in your cases, 2 cases.
Lord,
Why should I
Yes, why different
go
order?
in a different tangent today?
My lord, I am only thing is
Right,
that, my lord, this-
Mr. A.R. Vian, Senior Counsel, stated by Mr. I. Hussain, Learned Counsel for the petitioners. How many petitioners here?
Yeah, only, my lord. 15, my lord.
And
18
Mr.
petitioners.
D. Not Learned Senior Government Advocate for
1, 3, 4, and 5.
1, 3, 4, and 5, and Mr. R. Borpuzar, Learned Standing Counsel, Revenue Department for the response number 2, full stop. The petitioners, 15 in number, have joined together to institute this petition stating that they have a common cause of action to espouse, full stop. the petitioners have stated that they have served with notices, comma, all dated 9/6/2025 by the respondent number,
Circle Officer, my lord.
by the respondent number
5, my lord. Page 6.
asking them. This is different, revenue circle,
Revenue Circle.
different
Uh,
than yesterday.
Same, my lord.
Oh, same.
Same, my lord.
Circles of village area is different. Area is
Village is different, circle is same, my lord.
Circle is same. A calendar order, no? A content to yes, or translate. But the petitioners have submitted that they are in long and continuous occupation of the different parcels of land within Thekiajuri revenue cycle, and they submitted applications for
My lord, allotment under the Bosundhara scheme, my lord.
allotment,
My lord.
stroke settlement of those parcels of land
That have
under
been
Mission
rejected.
Bosundhara, but the respondent authorities had arbitrarily
Rejected, my lord.
rejected those applications. Full stop. Have you annexed?
Yes, my lord, from page 51, my lord may be pleased to find, rejected by circle officer on field inquiry, the land is found to have been encroached in recent years in an organized basis and is therefore excluded from the purview of Mission Bosundhara. The bottom of this table, my lord.
All in 2023.
My lord.
Okay, in the year 2023. Full stop. Mr. The petitioners have approached this court seeking inter alia direction to set aside and quash the impugned notices dated 9/6/2025 and not to evict or take any coercive action against the petitioners in respect of the plots of lands which are stated to be under their long and continuous occupation. First of all, Mr. Nath and Mr. Borbujari have vehemently contended that as on date, only a notice has been served upon the petitioners, asking them to submit all the supporting documents as against the complaint regarding their unauthorized occupation. First of the petitioners therefore have to respond to the said notice. It is only after a hearing, only after hearing all the stakeholders, a decision will be taken as to whether the process, any process of eviction is to be undertaken. And if such process of eviction is to be undertaken, then such process of eviction will be taken strictly as per the procedure in law, as per the procedure, but following the procedural safeguards, the procedure established by law. Post of issue notice, returnable on so and so. But you respond.
My lord, we'll report to this notice, my lord, because my lord,
Issue
today
notice, returnable
is
on
the
so and
date, my
so,
lord.
as Mr. So and so appeared accepted notice. No formal notice. The petitioners, as the notices dated 9/6/2026 has been served upon the petitioner to respond. Come the petitioners shall respond to the said notice by filing their replies. First of, if after the completion of the proceeding and during the pendency of the petition, the state respondents initiate any coercive action, the petitioners are at liberty to raise the said issue at an appropriate stage.
My lord, today is the date for my lord reporting to the notice, my lord. May I pray for an extension, my lord? Within 2 weeks, my lord.
Yesterday, I have granted 15 days in both the cases. The petitioners.
Also, maybe please to make an observation. That will, my lord, give a rider to the authorities.
Yes. Itu hai para 3 ya, era para 3 yes, yes, para 3. Yes. Para 3 put for you.
Deliberately choose to come at the last moment.
Not deliberately, my lord, but to certain.
Oh, no, the statistics says so, my lord. One after another repetition and a very frankly.
One after another notices are being issued statewide.
Repetitions fag and then getting a leeway, my lord.
If the as per notice dated 9/6/2026, the date for appearance and submission of the supporting documents by the petitioner is today. Suppose the petitioners have failed to submit their replies and the supporting documents today, then they shall make an application before the respondent number 3 within 3 days from today to afford a time period of 2 weeks to them to submit their replies with all the supporting documents in connection with the subject matter of the notice. To submit, if such applications are filed within the said period, within a period of 3 days, the respondent number 5 shall consider the said prayer, said request of the petitioners for granting them 2 further weeks time to submit their replies along with all the supporting documents in response to the notice.
0708, 7th August.
Mal.
Item 41.
EC.
Yeah. 41.
Counsel for petitioner is appearing through.
May I please, Lordship? May I please, Lordship?
Yes.
Lordship, I'm appearing for the petitioner. Lordship, this petition, there are twofold prayers before my lords. Lordship, firstly, the proprietor, the petitioner before my lords. I hope I'm
Voice
audible.
is not clear. Maybe from your end, volume is to be increased.
No, it is from my side, it is full. I don't know. No, I'm audible, Lordship. May I please, Lordship?
Mr. Counsel, not audible. Sorry, I was not audible. And voice is.
Am I audible now, Lordship? Am I
Voice is
audible
breaking now.
My apologies,
Voice is
Lordship.
breaking.
I can hear my lords very clear. Perhaps there is some issue at my end.
How can it be possible, Mr. Counsel?
Yes, my lord, pass over this.
What is the issue?
So, this is a matter where the this petitioner Nalwa Enterprise, Nalwa Enterprise, and the respondent number, respondent number.
It is by an order of the Chief Judicial Magistrate.
Yes. So the respondent controller of the defense account credited 1 lakh, 1 crore 4 lakhs and 47.
You should notice at this stage. And who is this respondent number 6?
Respondent number 6 is
What is his address?
Enterprise.
My lordship, may I? My lordship, may I?
Who is addressing the court?
My lordship, I am the another advocate from Delhi, representing Nalwa Enterprises. My lordship, I request my senior counsel to
I am
just
not seeing you in the screen.
uh,
Mr. Counsel, find out, rectify what is going on after some time.
my lordship, am I audible?
We'll pick up, inform them.
Item 42.
Your lordship.
Yes. What is the issue here?
Here is the, my lord, page 19, my lord, that is a notice issued. There is translated portion is there.
19.
Yes, my lord. Page 16 is the translated portion, my lord.
19.
Yes, my lord. This notice has been issued.
19 is Jamabandi.
Or Zamabandi, yes, my lord.
Huh?
From here I will start. As per the Zamabandi copy, my lord.
Notice is at page 41, my lord. Page 41.
The translated portion, page 41, my lord. This is under section 165, 1, 2, and 3. This notice has been served.
How you are agreeable with this notice?
Agree with that, my lord.
It is a chapter 10.
Yes, my lord. Chapter 10, my lord. But as per the Zamabandi copy, my lord, the land which he have mentioned, my lord, that is Meadi land in the name of some Pugulia, my lord. Where, with whom, my lord, a civil suit we have running from 2022, my lord.
That will not come in the way for this notice, civil suit.
Yes, my lord. Pendency is
That
not sufficient.
civil suit
Yes, my lord.
will not come in the way.
Yes, my lord.
This is a chapter perhaps with presidential assent.
Yes, my lord. That is
Right. So this will not come. Everything, if it is, it cannot be something which is there,
yes,
cannot be made legal if it is not there.
Yes, my lord.
Be it patta, whatever. Axonia, Miadi.
But
You respond.
my lord, let me submit, my lord. Last 30 years, my lord, they are remaining there. The dispute in between them, the Pattadar in the name of Pugulia, my lord, Miyadi Pattadar, that is running there. Case is also pending, my lord. Now they have.
But if civil suit is there, might be, it is a case that both plaintiff and defendants.
In adverse possession that has been filed.
Both plaintiffs and defendants are both will be riding the same boat.
Now the opposite party, my lord.
No, we are not concerned with this. Page 42, it is clear.
Yes, my lord.
And there is a PIL. Direction is there. So you respond to the notice. That's all.
My lord, that is here I have submission, my lord. We want to respond. We have been informed by today or tomorrow we will be evicted. As per
It
my lord,
cannot be.
only due procedure, my lord. Only due procedure.
It cannot be.
My lord, we are in apprehension. Only due procedure as per frame guideline. my
Yes,
lord.
Mr. This, are you, without completing the process, are you thinking of?
No, my lordship will kindly see, my lord.
I have read, now they are saying, I have read the page 42. It is loud and clear. Process will be taken to logical conclusion.
We have submitted our representation, my lord, accordingly.
The lordship will kindly see what is the suit all about. My lord, page 56 of the writ petition. For a moment, my lord. The suit itself is not maintainable.
That is notice issued there, my lord. They are not appearing the opposite party. Suit for declaration of the title perfected title.
Those are between private persons.
No, my lord. The Pattadar, my lord. The principal defendant is, my lord, page 55. Lordship will kindly see.
Ramlal
Pugalia.
Right. Those are between private persons. State is not concerned.
The state is not concerned, but this Pugalia is a tribal person.
Mister, I have understood you. I have already indicated to him that it might happen that plaintiff and defendants Both will go in the same boat.
Both will go in the same.
Same boat.
And even, my lord, that one cannot even seek title, perfect his title by way of adverse possession or otherwise. There is a straight bar under, my lord, 164A. 164.
And it is to be read with Article 246 perhaps.
Yes,
Of the Constitution.
yes.
Yes. You respond, you wait.
I have responded, only my lord apprehension is that, my lord. I am not saying that, my lord, another, other submit, only thing is, my lord, due procedure.
PIL, what was the direction?
PIL, my lord,
That PIL went to Supreme Court.
yes,
There was a direction.
yes.
Where is that?
That direction.
Give it that, we'll close. We close.
That
That
direction.
PIL, travel belt, is it not? That went to Supreme Court. Supreme Court gave a set of direction that this is the manner in which.
Right of hearing.
Yes.
So right of hearing has, that has been
Right.
an opportunity.
Now let us put the Supreme Court observations.
Yes, Supreme Court of the.
Against that PIL,
Yes, madam.
matter is to Supreme Court, perhaps.
Yes, yes.
And Supreme Court has gave a set of direction. In that PIL,
In that PIL.
we'll incorporate that.
Only,
That proceed, right,
Yes,
in your benefit, procedural safeguard.
yes, my lord. Only summary eviction may not be done, my lord. That
Tomorrow.
is-
Summary, in fact, it is already.
Summary eviction may not be done, my lord.
Let us see. Get the order tomorrow.
Yes.
There is an order
Yes.
where Supreme Court has laid down certain guidelines and procedures, perhaps, if I remember it correctly, then we'll incorporate those regarding the chapter 10.
It went from, my lord, Kokrajhar district. Yes, I remember.
Get the order. That will be in your benefit.
Yes, ma'am.
A.Y. Chaudhary petitioner are Barbujari. And so far, the general counsel for the parties is the case tomorrow. Well, Supreme Court has laid down the guidelines. Why we should get laid down the guidelines?
Absolutely, but this notice itself is in consonance with that guidelines.
Yes.
I will satisfy, my lord, tomorrow. Yes.
I'm satisfied you get the judgment.
Yes, fine.
Timing matters, item 8.
Yes, what you were asking?
Now objection has been.
Yes, Mr.
Objection has been cleared, my lord.
What objection was there?
The lordship, that copy.
Okay,
Yes, it was provided to me.
okay. Yes, Mr. Sharma.
Yes, lordship, my learned friend has already annexed this orders, lordship.
Which order?
One order is at page 17.
Another is page 19.
Okay, 17. Mr. and
M.H. Soikia, M.H. Soikia,
M.
M.H. Soikia.
M.H. Soikia, learned counsel for the petitioner. Mr. H. Sharma. Who is there? And Bordoloi. Revenue.
And for 2, 3, and 4.
1. H. Sharma. 2, 3, and 4. This page 17 is same?
My lord,
Area is same.
my lord.
Your predecessor name?
Maqbul Sheikh,
Maqbul Singh.
Maqbul Sheikh.
Village Bamunpara.
Village, my lord, Hujjo Khata Part 2.
Give this order. 6/2026 order to the council. Correct it by hand. We'll type it. No point. Same order. Status quo.
My lord,
Why can you returnable on the date of review? August. Status quo. Same order. Just correct the name. Get a copy of that order. Get a copy of that order. Correct the name and pass the same order.
TTA related to.
14.
Item 15.
That was good. Page 17.
Yes. Now I have the notification. This your DAG number,
My lord.
Pata number is not under the process of acquisition. Prayer 11, page 11. Yes, you may have a case. If you have a case for DAG number 61, file a separate petition. Right? But so far as your DAG number 554, it is not acquired at all. So no point keeping it pending for 6 more months. Notice issued. So I take your word, Mr. Talukdar, that both under section 3A,
3A and 3D.
3B,
3D.
3D. Okay, 3D, then almost over.
Yes, Lord.
Heard Mr. S. Das, learned counsel for the petitioner. Who is for land acquisition. Department is there. No. Mr. R.K. Talukdar, learned planning counsel NHI DCL for the respond number 2, and Mr. N. Das, learned junior government advocate for the respond number 3 and 4. Full stop. The petitioner has approached this court by the present writ petition, seeking the following pair. Page 11. A and B. Then also interim. Para Mr. Talukdar, learned standing counsel, NHI DCL, has placed a copy of the notification dated 10/3/2023, issued under section 3 capital A, bracket 93A, within bracket 1 of the National Highways Act 1956, and another notification dated 29/5/2023, issued under section 3D, within bracket 2 of the National Highways Act, which are also published in the official gazette. To buttress the point that any plot of land, any area of land within DAG number 554 and KP Pata number 340 at village, revenue village, Kukurmara, Moja Soregaon, Ponton, Soregaon Revenue Circle, District Kamrup, was not brought under the purview of the land acquisition process. Full stop. The land acquisition process has already been completed, and by the notification dated 29/3/2025, issued under section 3D within bracket 2 of the National Highways Act, the lands described in the schedule therein have already been vested in the central ground. Post op. Whereas in the aforementioned notification, any area of land under DAG number so and so and Pata number so and so has not been brought within the purview of the acquisition process, comma, the writ petition needs no further adjudication, and accordingly, comma, the writ petition is closed. Full stop. Mr. Das has further submitted, learned counsel for a petition has submitted that another area of land under DAG number 26 and annual Patta number, under annual Patta under possession of petitioner was taken within the purview of the land acquisition process. If such area under diagram number 26 is brought under the purview of the acquisition process, the petitioner is at liberty to seek appropriate remedy permissible under
That
the
is
law.
also not, Lordship. That is also not taken.
Let
Yes.
him come.
Lordship.
Let him come.
Lordship.
You bring the notification.
Yes, Lordship.
We'll dismiss the petition in limine.
Lordship.
36.
Yes, big bulky. Yes.
The petitioner or the authorized dwellers, can see page 31. This is the agreement.
37. Page
31, my lord.
31.
Photocopy of original, my lord, 35.
35.
35. This is the agreement, my lord.
Desires to render services.
And type copy is there, my lord, on 31, page 31.
Excellent.
On behalf of Governor, my lord, Divisional Forest Officer signed the agreement.
Udmari,
Udmari.
Jamuna Modanga Reserve Forest.
My lord.
Reserve Forest.
Reserve Forest, my lord. And they settled us, my lord.
When?
With the condition 1971, my lord.
And this forest was reserved when?
Reserve earlier, my lord.
Which day, which year?
Yeah,
Reserve forest which year? Yes. Okay, then. Okay, proceed.
My lord, then, my lord, can you see page 186, my lord. Certificate.
One?
186.
17.
86. Yes.
The certificate, my lord, issued by the range officer, forest range officer, my lord.
50.
Okay.
My lord, they are the petitioner are providing service, free service to the forest department, my lord. And some documents, my lord, are annexed, my lord, at page 76, my lord, original in vernacular and type copy, my lord.
Then?
76, my lord.
Okay, I have seen labor service.
My lord.
Labor service.
Labor service, my lord.
Hmm.
And they allotted us 6 bighas of land, my lord. And my lord, kindly see, suddenly they issued a notice, my lord. That
This notice was subject matter of earlier petition, perhaps?
yes, my lord. And they stated, since you have illegally occupied, my lord, how can they say that we are the illegally occupied?
Okay.
Since there is a substantive document is there.
Then what
is
happened
there.
on this notice? Page.
Then, my lord, they again, my lord, issued notice to us, my lord. As per the
Page annexer 4 series. Annexer 4 series.
4 series.
Page 2 to 6.
No, my lord. Annexure.
226.
Two to six earlier notice, my lord. Earlier. Then, my lord.
You received those notices.
Yes, my lord.
Then what happened?
We came before this honorable court.
You came before this court.
Yes. And the honorable court, my lord.
Where is that order?
Page 337.
337.
337. Okay. What is the operative part? Then disposed.
Paragraph 10 and 11, ma'am.
10.
346.
Oh, that Abdul Khalik.
Yes.
That Abdul Khalik, my lord.
Taking into account 9 officers will constitute a committee. This committee is of forest and revenue.
Yes.
Forest Revenue Police.
So,
We.
just a minute, just a minute. Responsible constitute committee comprising of forest office and revenue. That issue notice to earlier and will give an opportunity to adduce evidence. They have a right to occupy the land to show that. Action of removal shall be taken only if found that there is encroachment. It is found to be within the revenue limit. The state to remove encroachment. Okay, then
My lord, we are protected, my lord, by the Forest Right Act 2006, my lord. My lord, can we see?
then what happened? This new this notice.
Yes,
16.6.
my lord.
Let us see that 16.6 first. We were in occupation land, we were notified forest area. Notified by okay to 1915. 1915 and 1917. Okay, this notice.
My lord.
Respond.
My lord, can we see? They cannot evict us. My lord, can we see the section?
Mr. Atia,
Forest
Mr.
rights?
Yes, Mr. Atia, whatever they have a right to issue notice and you have a right to respond.
Yes, my lord.
And your earlier round itself, it says,
My lord,
earlier round itself says, you have to respond to the notice. You respond.
I already submitted all
And
documents, my lord.
everything will be as per Abdul Khalik and that judgment.
My lord, Abdul Khalik, that case was for the person who illegally entered, my lord. I am not illegally.
They will
entered.
examine.
They are not examining, my lord, because they are.
So we'll examine. If they fail to examine, we'll examine.
Make a direction.
Because page 345, Roman 6. T45, Roman 6. A speaking order shall be passed.
Speaking order shall be passed.
This is only notice.
My lord, earlier occasion, my lord, we approached them, my lord, we submitted all the documents. Then they again came and they directed us to vacate the land.
This is as
We
per,
are
as
verifying
this
all
notice is
documents.
as per the coordinate bench judgment in Abdul Khalik. This notice is as per Abdul Khalik and the earlier one, coordinate bench judgment. We can't help it at this stage. You file your response.
I filed my
16/6, we are on 25/6. Respond.
speaking order. No
If you have not responded, have you responded or not?
my lord,
Huh?
Not filed.
already filed.
File.
Yes, already filed.
You have filed reply.
Yes, my lord, already filed.
Let them pass.
But they have not annexed the reply, my lord. They have annexed the impugned order notice, my lord. They have not annexed the reply. There is no statement to that effect. They have submitted a reply, my lord.
My lord, they came earlier, my lord.
No, Mister,
They-
I have seen 345 is clear. Right. Page 345, Roman 6 is clear. I will not sit in appeal over that Roman 6 clause. You have to respond. Plain and simple.
already-
345.
My lord,
Then they have to respond. Then they have to respond by speaking order.
Speaking order, please, no coercive action, my lord.
What speaking order? Already there, you are protected. Thereafter shall be served, giving them 15 days. You come within that window. You come within that window.
Come in,
Why after order?
threatening us to vacate, my lord.
These are mere statements.
You are protected by the
Well,
procedural safeguards put in place by Supreme Court, put in place by a coordinate bench of this court. Why the third layer of security?
Well, can we see,
No third layer of security.
can we see,
Huh?
my lord?
You want, what is that?
Despite
What is that?
all the documents, my
What
lord,
is that?
They are,
Z plus.
they are,
Z plus.
my
You are in Z category now.
lord.
Don't ask for Z
see,
plus category. Supreme Court safeguard is there. Coordinate bench
Yes, ma'am.
safeguard is there. Why?
Well, can we
We'll
see?
issue notice only. Right, Mr. AJ Atia, Learned Counsel for the Petitioners. Already you are saved.
But they are not following that, my lord.
How can you say
Still
that?
they are saying us the illegal enforcer, my lord.
Have you, have they said in writing?
Yes, my lord.
Have they said in writing?
Yes, my lord. Yes, my lord, can we see the notice? The notice, they earlier issued the notice and stated that.
1, 2, 3, it is clear. Mr. P.N. Goswami, Learned Additional Advocate General, Assam, listed by Mr. K.V. Pathak, Learned Standing Counsel for his department for all the aspirants?
All the respondents.
Okay. The petitioners have approached this court, agreed by service of notice, service of notices, all dated 16/6/2026, whereby and they have been asked to respond by submitting replies along with all the documentary evidence within 7 days from date of receipt of the notice to establish that they are legally authorized to occupy forest land within the notified forest area of Jamuna Maudanga Reserve Forest, which was notified under the Assam Forest Regulation
1891, ma'am.
on 21/9/2019-15 and 15/5/2017. Post of Mr. Ati has submitted that the petitioners have already submitted their replies along with all the supporting documentary evidence, and they are now in apprehension of being evicted without the speaking orders are passed. Post of para. A coordinate bench of this court in a previous, you were the petitioners there?
Yeah.
In a previous petition, WBC number 433/2026. In its judgment and order dated 12/2/2026, has inter alia observed as under para 13, page 347. Issue notice. Returnable on students.
My lord, one observation, my lord, the state should be at liberty to proceed according to the Honorable Supreme Court's order.
And coordinates.
That may be recommended.
Para 13 I have written. I am quoting 347. Look at 347.
Yes, ma'am.
Paragraph 13.
Yes, ma'am.
I am quoting that.
Yes, ma'am.
I am quoting that, paragraph 13. Issue notice returnable on
That will, my lord, that will be a status quo order
No.
in favor of the petitioners, ma'am.
The parties are directed to maintain status quo in respect of land in accord till speaking orders are passed. Till.
But now they have not filed reply. That is my contention, my lord. They don't file reply. I cannot file a issue a speaking order, my lord. In the process, they will be inside the
I
forest.
have recorded.
Yes, record, my lord.
I have
They have
recorded.
filed, my lord,
I'll again
but they have
record.
not- They have
Then,
not.
my lord,
He has submitted, Mr. Atia has submitted that all the petitioners have responded, but already I have submitted.
that I understood. my lord.
As the petitioners have stated that they have already submitted their replies along with all the supporting documents from the respondent, the competent authority. Who is the authority?
That committee, my lord.
Okay.
District level committee.
Okay. The respondent authorities are at liberty to pass the speaking orders.
And if not filed, my lord, then also will proceed according to Abdul Khalik, my lord.
Okay.
That is relevant, my lord, because they may not file, my lord, and we'll have to wait.
My lord, what?
Then they could have annexed the replies, my lord.
Issue notice returnable on so and so. As so and so, Mr. Pathak has appeared accepted notice, all. No formal notice, extra copies by tomorrow. Court has taken note, this court has taken note of the judgment of the Honorable Supreme Court of India in Abdul Khalik and others versus State of Assam and others. Civil appeal number, anything? Somewhere?
Yes, ma'am. Abdul Khalik, right, appeal number.
And the judgment and a judgment.
SLP C number 23647.
Page, which page?
It is not enclosed.
Not enclosed, my lord.
But anywhere mentioned?
Yes, I have a.
Page, you write down the page.
No, it's not here, my lord. In this proceeding, it's not there, my lord.
No, in the body of the petition?
Body of the petition, my lord.
No, here inside all this, not there.
That has not been. No, no,
Abdul Khalik and others.
I'm giving the number, my lord.
And and the judgment and order dated 12/12/2026 passed in WBC number 43/2026.
10 minutes.
Post of
10
in Abdul Khalik and others, comma. The Honorable Supreme Court has observed that under 344, paragraph 12. And post of next paragraph. Taking Q CUE from the decision in Abdul Khalik Supra, the coordinate bench has observed as under paragraph 13, page 347. Para, in view of the observations, above observations made by the Honorable Supreme Court and the coordinate bench of this court, and considering that fact that the petitioners have already submitted their replies along with all supporting
But they
documents
had to give me receipt, man.
in response to the notice dated 16/6/2026. The respondent authorities shall proceed in accordance with the procedure mentioned in the above judgments and orders.
But they are not issuing receipt.
Now
my
they are
lord.
saying that we have not issued the receipt of that,
Yes.
receipt of that representation, my lord. They have not submitted, my lord. That
Yes.
my contention, only my contention may be recorded, that has not been submitted.
Yesterday,
Are you sure?
yes, my lord, yesterday
Or-
they came, my lord.
Or
The petition came
Mr. Atia, if you want to file, you can still say.
Yes,
I
we can grant
give
them
you
further time.
I can give you time and also with a direction to receive acknowledgement of
yes.
the
Oh,
reply.
yes, yes, man. Yes.
He can
It
be
is
either
very
way correct.
simple.
He cannot be both way correct, my lord.
My
Then
lord,
both
can you
both
notice
are
that
bound.
should be issued, my lord.
Then we'll dispose of.
Yes, my lord. In fact, my lord, in the meantime, same.
If, okay, has submitted. Atia submitted replies. However, he has submitted that the respondent authorities have not acknowledged the receipt of the replies. Full stop. Taking note of the submissions of Mr. Atia, that receipt of the replies submitted by the petitioner are not acknowledged by the respondent authorities, the petitioners are granted 3 more days time to file their replies along with all the supporting documents. The petitioners, the petitioners, whose petitioners are permitted to submit their replies along with all the supporting documentary evidence before the divisional forest officer,
Before a committee, well, district level committee.
before the committee, within 3 days from today.
That will be 5 days, my lord. Or
5
even
days.
7 days, my lord. I have no objection.
7 days.
My lord.
7 days from today. And the committee is there.
He's the member secretary.
The member secretary, my lord.
Okay,
He received
divisional forest officer, which division?
Nagaur South.
Nagaur South Division, my lord.
Who is the member secretary of the committee?
District level committee.
Yes.
Within a period of 7
7
days
days
from
from
today. And on submission of such replies by the petitioners, the said authority shall receive the replies under acknowledgement. And a copy of the acknowledgement is to be given to each of the petitioners who have submitted their replies. Full stop. Then we will proceed, Abdul Khalek, and coordinate matters. The petition is disposed.
In fact, another batch, my lord, have been disposed of by last week, my lord. Same forest, same Tongia claim. Dismissed by single. Just that dismissed by honorable single judge. Now today dismissed by division judge. Same identical issue, my lord. Exactly, because they were not responding. That's why I was also of opinion that they should be granted some time.
7 days.
Obliged, my lord.
And I'll record your submission.
My lord. Deeply obliged.
41. Item 41.
Yes.
Apology for a technical dispute.
My apologies, Lordship, for this technical.
We'll issue notice then.
Lordship.
There is no Indian prayer also.
Tomorrow.
There is no
My
Indian
lordship.
prayer also.
My lordship, I would like to represent the matter.
For petitioner or respondent?
Petitioner, my lordship, I am representing Nalwa Enterprises along with my senior counsel, Advocate Jaspreet sir. My lordship, from between the period of 31st December 2025.
Madam, we are issuing notice at this stage.
Notice is being issued.
We are issuing notice.
Lordship.
What,
Yes, my
Mr. What is the name of?
Rasna S. JS Rai.
JSI, Senior Counsel,
No.
Learned Counsel, and Mr. JSI and Miss
Rasna S.
Rasnas, through the virtual mode, along with Mr.
A Sharma.
A. Sharma, Learned Counsel for the petition. Having regard to the issue raised in this petition, let notice be issued. But your respondent number 6 is
My lordship, he is
Not
also unknown
respondent.
for us.
Private
too.
respondent, this is.
where is
He's the
his
third-
address?
My lordship, he is the
Lordship, I will rectify this.
You cannot rectify in this way. You have to
May
file
I,
IA.
lordship?
We'll file.
File, but you cannot issue notice at this address. As let notice be issued. The notice is made returnable on so and so. Petitioner shall counsel for the petitioner shall take steps for service of notice upon the respondent number 1 to 5 by speed post within 2 working days from today in view of incomplete address of the respondent number 6. Notice is not issued at this stage.
14th August.
Obliged.
My lordship, the address of the respondent number 6 is mentioned in the petition which they have filed. We have never met the
I can't
respondent
help
number
it.
6.
Production list. Item number 1.
Please, my lordship.
Yes, sir.
Here in the petitioner, she was elected as the officer member, your lordship. She was elected as
Where is the MP order?
page 30, your lordship. Page 30. Your lordship.
What is the qualification required?
Metric, your lordship.
Do you have
be a
any
member-
SEBA certificate?
No.
SEBA.
No.
No.
No. He out of Assam, your lordship, he passed.
Board of Open Schooling,
Yes.
Gangtok.
But here in your lordship, the case is that your lordship.
Where is your mark sheet?
Page 33. Your lordship.
Established by Sikkim. Pass criteria. This Sikkim is a party here.
No,
Huh?
Sikkim is not the party.
Not a party. How can we verify?
But here in your lordship, my case is that your lordship, before passing this order, your lordship, the petitioner, he was not heard. And one transfer certificate has been mentioned here in this order. And I don't know anything about that transfer certificate. And it was not brought within the knowledge of the petitioner.
Inquiry report.
And that inquiry report, your lordship, if something was done, that was done back behind the petitioner.
You are okay. Elected member has been disqualified. We'll issue notice at this stage.
But here is the case is that your lordship, so far
If it is in violation of principle of natural justice,
the principle
we'll
of
restore back the position. Is any election is announced?
no.
Issue notice.
The,
But Mr. Kaur, you find your response immediately.
Yes,
You
sir.
can decide it.
yes, sir.
If no notice, it is to be set aside.
Yes, yes, sir.
Heard, Mr. A.M. Khan, Learned Counsel for the petitioner. Mr. K. Kaur, Learned Standing Council Panchayat and Rural Development Department for the respondent number 1, 2, 5, 6. M. Bormon.
He's addressing the.
Okay. Okay. Additional advocate general. So, for all the respondents of 1, 2, 4, 5, 6. Petitioner. In this petition, the petition is a sale and order dated 19/6/2025, whereby passed by the respondent number 4, whereby the petition has been disqualified and removed from the office of the ward member of Rongapani Gaon Panchayat, Sri Jangam Development Block under section 1112B of the Assam Panchayat Act 1994, post of para. Mr. Khan, counsel for the petitioner has submitted that the impugn order has been passed on the basis of a report submitted by the Chief Executive Officer Bongaigaon Zilla Parishad. Report dated 16/3/2026. And the petition was never heard prior to passing
It is
the impugn order. So, post of the report dated 16/3/2026 has also been not served upon the petition. So, the matter would require consideration. Issue notice returnable on so and so as Mr. Kaur appeared accepted. Notice 1, 2, 4, 5, and 6. No formal notice, extra copies. The learned counsel for the petitioner shall serve a copy of the petition to the Land Standing Council, Assam State Election Commission, within 2 working days from today for service of notice upon the respondent number 3. The respondent shall bring their stand by filing the counter before the returnable date without fail.
In the meantime, you have some protection may be given here.
We'll set aside.
Because the respondent may go for re-election, your lordship.
You come.
That may be your lordship.
You come. Election is not a small exercise. But you come.
Re-election, I am saying, your lordship. That may be restrained, the lordship.
Will not restrain election process. If election is initiated, we'll take up your petition.
Since I have been removed, your lordship, and therefore only I am saying, your lordship, for against that ward member, your lordship, they may.
It is not easy.
For re-election. That can be, your lordship.
You come, we'll decide your petition then and there.
The date, your lordship.
12 August.
I got you.
29 July.
All right.
Item 2, Modandas versus State of Assam.
Lordship, petitioner is a tenant who has filed a suit before the learned civil the junior division against the landlord and another. Another is the defendant number 4 and is the respondent number 4 before this honorable court. You know what has happened? Along with the suit, the injunction application was also filed. By an order dated 16/2026, an ad interim ex parte injunction was granted and I was protected by the learned civil court, and my lord will find the injunction order at page 40. Page 40, my lord, it starts. Page 40, annexure 5. Okay. My lord, may kindly come to the operative portion, my lord, at page 43. May I read, my lord, paragraph 12, my lord. Therefore, considering above, I deem it fit to grant an ex parte ad interim order restraining the opposite party from disturbing the peaceful possession of the petition of the scheduled property, and also restraining the opposite party from unlawfully evicting the petitioner from the scheduled premises, and also restraining the opposite parties alienating the scheduled suit premise to any third party. The ad interim ex parte injunction order shall remain in effect until filing of the objection by the.
What is the suit property?
My lord will find the suit property in the plain, my lord, and page 30, my lord. Page
30.
Yes, page 30, my lord.
E0. Okay, 30. 30. Now, what is the name of the petitioner?
Petitioner is Madan Das.
Hmm?
Thereafter,
Madan Das.
yes. Thereafter, my lord.
Madan Das.
Yes.
Why he sought the suit? Or instituted?
For seeking declaration.
Okay, and this order was in injunction application?
Yes. Injunction application.
Order 39.
Order 39, Your Honor. My lord. Ad interim ex parte was granted. As interim ex parte was extended, and the suit is now fixed on once on a subsequent date. The respondent number 4, who is the defendant number 4, appeared and he filed counterclaim also. Your Honor.
Defendant number 4, Torun Nath.
Yes, he is the respondent number 4 herein in this writ petition. And he has filed counterclaim, and my lord will find he has filed written statement as well as counterclaim. My lord will find his counterclaim at page 7.
Now, why you have come?
Now, my lord will kindly come to paragraph page 96. Apparently, my lord.
96.
Yes.
Let me go through.
The translated and typed copy. Page 96.
Yes.
Cannot.
Cannot, Lordship. Mr. NBP Singh, Learned Counsel for the petition. Mr. A. Aforesaid. Revenue 1. H. Sharma. 2 and 2, 3, 4. 2 and 3. The petition has approached this court by the present revision to assail a notice dated 22/6/2026, issued under the hand of the respondent number 3, who submitted notice, the respondent number 3, on the allegation that the petitioner has been illegally occupying and encroaching upon a parcel of land, covered by DAG number 2528 and KP Patra number 1445, situated at Dharapur, village Dharapur, Maujar, Amsuran, district Kamru Metro, subject plot, has been asked to appear before him on 24/6/2026 to submit his explanation along with all the relevant documents. From the notice, it transfers that the proceeding before the respondent 4 has been initiated at the instance of the respondent number. The proceeding has been initiated before the respondent number 3 at the instance of the respondent number 4 and the respondent number 5. The petitioner, as the plaintiff, has instituted a title suit, title suit number 35/2026 before the Court of the Civil Judge Junior Division number 1, Kamrup Metro, wherein the respondent number 4 herein has been arraigned as defendant number 4 in an application filed by the plaintiff under Order 39 Rule 1 and 2, read with 151 CPC, which is registered as Mise case number 84 of 2026 in the state's title suit, the London Trial Court on 16/2/2026 has passed an ex parte ad interim order restraining the defendants, thus of opposite parties, from disturbing the peaceful position of the petitioner over the scheduled property, and has also restrained the opposite parties, thus defendants, from unlawfully evicting the petitioner from the scheduled premises, and also restraining the opposite parties, thus respondents, from alienating the scheduled suit premises to any third party. Mr. Sinha, learned counsel for the petitioner, has submitted that the said ad interim ex parte ad interim order has been subsequently extended, and as on date, the said order is in currency.
Yes.
Issue notice returnable on so and so, as Mr. So and so appeared accepted, no formal notice. Steps upon respond number 4 and 5 by registered post or speed post within 2 working days, as the scheduled property in title suit number so and so and Mise case number so and so is the same as the subject of mentioned in the interim notice dated 24/6/2026. It is ordered in the interim that operation of the notice dated 24/6/2026 shall remain in abeyance till the return.
12th August, 1208. Item 3, Imtiaz Zaman versus State of Assam.
Well, the issue raised in this writ petition is very simple. Well, I have been summoned by a police officer of the cyber police. I asked for the case number, they don't come give the case number. They don't tell under which FIR I have been asked to come. They don't give me any notice. So your lordship will ask my learned friend to at least have the instruction by tomorrow 2 o'clock under which case I am wanted.
2
So that
o'clock?
I can take the last day of the vacation.
You're making me to sit up to 5 o'clock.
No, just this
Last
instruction.
vacation, I have to close the High Court at 9 o'clock. I was the last person to
Well,
leave.
at the vacation.
Yes, get the instruction.
Only the instruction.
Lordship, by tomorrow, in that case, it is better to ask the PP Lordship, because it will be convenient on their
Call
part.
Mr. Gogoi.
In their part, it
Call
will be
Mr. Gogoi.
Lordship. Both the cases 3 or 4, they have only to obtain the instruction on which case.
Let Mr. Gogoi come. K. Gogoi.
I'll call him.
Yes, yes, Mr. Chaudhary, you are waiting for what?
I will not trouble lordships in the sense that we have filed an
22.
application for infringement, but I have now noted that there are some inadvertent errors that have crept in. Permit me to withdraw and refile it again, let it come after vacation.
Oh,
Mr.
good
Chaudhary,
enough.
waiting for that.
After vacation, I'll permit.
Yes, yes, sir. So permit me to withdraw.
Oh, liberty.
With a liberty.
Okay. Which one?
Item
number 23.
23 lordships.
Okay, Mr. M. Goswami, Learned Senior Counsel, except by Mr. R. Sinha and Mr. K. N. Chaudhary, Learned Senior Counsel, except by Mr.
S. Mitra.
S. Doctor.
S. Mitra.
Mitra, Learned Counsel for the opposite party is present. Applicant. Mr. Chaudhary, Mr. Goswami has submitted that as certain inadvertent errors have crept in the application, the applicant wants to withdraw the writ petition with liberty to file affairs.
I want to withdraw the IA.
IA only?
Yes.
This IA?
Yes, IA for implement. Sorry.
I said that is why applicant, I change it to
My
applicant.
colleague is anxious, he says, please. I'm sorry.
Applicant. In view of the above submission of Mr. Goswami, the instance application stands dismissed on withdrawal with the liberty as paid for. Yes, anything? We'll not take up all these hearing admission matters.
Look, it is a
Let us make it clear.
There is a
Tomorrow also I am not taking up admission
There's
matters.
no urgency. There's a matter for stay vacating.
Which one?
Item 22. My lord, here, my lord, my learned friend is the respondent, I'm the writ petitioner.
Who has filed the?
They have filed the.
We'll issue notice then.
No, they have filed the stay vacating petition.
I'll not adjudicate.
No, need not, my lord. Only thing is, my lord, let it come up for admission, the entire writ petition can be heard. And
No, it is there. Let it be there.
That-
After vacation, we'll fix that.
My lord.
It can be decided either IA or if the court feels that 75% efforts will go in deciding the IA,
Absolutely.
then court will go for.
Absolutely.
This is what I do.
My lord.
If I find that 75% efforts are to be made in IA,
My lord.
why not 100% for the entire?
My lord, that's what, my lord.
Okay, Chakraborty for the applicant and Mr. D. Chakraborty for the opposite party petitioner.
Yes.
Are present. Mr. Taluga is there.
No, Lordship, under this.
Okay.
Revenue is there, my lord.
Revenue is there. Revenue.
Was there a while back.
Okay.
A Bhattacharya was there.
Whatever. Government advocate there. Okay. Mr. Dinath is involved or Sharma, H. Sharma. Are present. He is present. As sought for and agreed to by the Land Council for the parties, is the case on switch. Interim order passed earlier shall continue till the next date of
Deeply.
Take the date from
Item number
My-
2907.
Item number 29, my lord, there is a difficulty, my lord. 5th, 6th, 7th. August.
7.
29.
0708.
Look, in item number 29, it's a eviction matter. We have issued notice. They have submitted their reply. Taking order has been passed. We have filed the affidavit today. So Lordship may immediately after the reopening, Lordship may fix a date.
Okay, Bhuyal, serious.
We have to respond.
Yes.
Respond after vacation only.
After
It's the first week of August, my lord.
No, my lord.
No, my lord, what is the difficulty? I have some medical issues, my lord. I may not be available immediately, my lord. That's fine.
Look, I am expressing some urgency because already we have submitted the affidavits. Their documents have been considered. We found, my lord, that all of them are the Aadhaar card, the documents they have shown. Those are belonging to Nagaon district or Morigao district. They don't belong to that place. They are occupying government land. And time has been
Yes,
given.
Mr. Bhuya, when earliest next month?
My lord, in the last part of July.
Okay, last part of July.
Kindly
All are, otherwise all days are loaded already.
27
Good
27
enough.
of July.
My lord.
A.R. Bhuya, Senior Counsel for the petition, Mr. D. Nath, Senior Government Advocate Assam for the respondent state responsible present as sought for and agreed to get the counsel for the parties. This is the case on so and so. The petitioners may file their affidavit reply. In the meantime, if so advised, the interim order, anything?
Yes, my lord. There is an entry.
Interim order?
They were directed to submit their reply. Until then,
No,
not to take.
there
any
was an
action.
interim order, my lord.
This will not be.
Okay.
Interim order was there, my lord. That may kindly continue.
29.
So, I'll read it. Order copy. Interim order.
Shall not be evicted. The interim order passed shall continue till the next date of listing. On the next date of listing, an endeavor will be made to give final consideration to the report.
2707.
Obliged. Yes, Mr. Taluja.
Lordship, item number 27, there is some urgency, Lordship. This is a
What
case of
today?
land acquisition, Lordship. Not today, Lordship, but immediately after vacation date may be fixed because
Get
due
an order.
to
Due to
tendency of
paucity
this.
time, the case could not be taken up today. As sought for and by the land council for the parties, is the case on sale. You will find out from the calendar.
Lordship,
Oh,
immediately.
ah,
He has already bring the case numbers which are pending against me so that I can take them.
My lord, report from the IO, my lord, regarding any case pending against.
In the cyber police station.
okay. Which police station?
Pandazan.
Okay, I have Mr. B.D. Kumar and the senior counsel state by Ms. So and so. Post of the petitioner and consequent senior consequent petition has submitted that the petitioner has been called repeatedly to appear before the respondent for
For 4, 5, 6, Malat, all. 4, 5, 6.
4, 5, and 6. But the petition has not been informed as regards any crime case reported against the petitioner
Or
in
FIR.
connection which the petitioner has been called repeatedly. Mr.
B. Sharma.
P. Sharma, Land Public Additional Public Prosecutor, shall obtain instruction by tomorrow as regards the submission made by the learned senior counsel appearing for the petition. Raise the case tomorrow.
Case is pending, I guess.
Regarding, no, sorry, about the reason for which the petitioner has been repeatedly called to the police station. Reason.
No, Malat, they have to disclose the case number, otherwise it will make
Reason, and if any
FIRs.
case, like FIR stroke case has been registered against the petitioner. And that if yes, come on the details thereof.
Detailed report, my lord.
The details thereof.
Maybe they may have called me as a witness, I don't know. The second item is also same.
Same.
My lord, copy of the, my lord, petition.
Even just a online copy now so that he can.
Fine, problem.
Lordship, I beg to mention item number 43. Just a date may be fixed after the vacation.
I am for respondent 1 here.
Hearing. Naam likhibele.